May I please, Your Lordship?
Yes, Mr.
Your Lordship, I beg to mention item number 46 and 47. Your Lordship, in this matter, I was directed by the order dated 27 May 2024 to furnish some documents. So I may be allowed to file those documents in the form of additional affidavit, and the matter may be listed next week on any date.
Let us see the record. 46. By which order?
27 May 2024.
Third, Mr. Intimson. Then additional age. Mr. Intimson submits that by the order dated 27/5/2024. The state was granted time to produce the records pertaining to the compensation process. Mr. Intimson, however, submits that he may be allowed a week's time to comply with the order dated 27/5/2024 passed by this court and to produce the records pertaining to compensation process. Where is allowed? Listed after a week.
Your Lordship,
Can it-
in the form of additional affidavit.
What was the last line? Okay, prayer is allowed. The records may be placed before this court in the form of an affidavit.
Worship, can it come up on Monday, my lord, 5th of August? Since he has already received the documents, it should not take much time for him to file the affidavit, my lord. This is the 4th time he has sought for time, my lord.
This is the case on Thursday, 8/8/2024. Okay.
May I please, Your Lordship,
Yes,
please allow me to mention hearing item 58 on behalf of Sor Alisek. My lord, on his request, the matter may be kindly be listed on 20th of August, since he has prior engagement before 20th.
Mr. Hakim Richabo, learned counsel for the petitioner, seeks adjournment of the case on 28/8/2024. Listed accordingly.
Obliged. Clear.
May I please, the Lordship?
Yes, Mr.
Lordship, I'd like to mention hearing item number 39, 40, and 41, Lordship. Lordship, by an order dated 18/6/24 and by order dated 4/7/24, Lordship, this honorable court has directed me to get an instruction as to whether the one petitioner, Sri Bentang Merin, his pata has been cancelled or not, Lordship. And to that effect, Lordship, I have been informed that that dealing assistant and as well as the record keeper, they are on casual leave, Lordship. One is on sick leave, Lordship, and one will be joining tomorrow and the other will be joining on Wednesday, Lordship. So if Lordship may please to list the matter either on Thursday or Friday, Lordship, to get an
My lord, for the convenience, if on Monday, as a fake said, I mean, I very much glad for.
What is the matter about?
My lord, here the question is, the Luka Yukta has passed in order after reopening the disposed case, giving a direction to the state respondent to cancel the lane bata which was held by the petitioner.
Has your pata been cancelled?
So far, as per my personal inspection, it's not been cancelled.
It's not been cancelled. Whether there is any stay passed by this court?
Yes.
Okay. On the prayer of Mr. V. Jimomi, listed after 2 weeks. Okay.
Much obliged.
Please, Your Lordship.
Yes.
Your Lordship, I beg to mention item 48 from the hearing list, Your Lordship. Here, Your Lordship, I'm yet to receive the complete instructions, so this matter may be listed after 1 week, Your Lordship.
MS, okay. Inaholi. Then government advocate. 6, adjournment of the case for a week. Prayer is allowed, list report.
Much obliged.
May I please, Your Lordship?
Yes, please.
Your Lordship, I beg to mention hearing item number 54. I pray that Your Lordship may list after 2 weeks
You are the counsel for the,
petitioner.
you are H. Ziliang
Yes, Your Lordship.
on the prayer of MS H. Ziliang, learned counsel for the petitioner. Listed after 2 weeks.
Your Lordship, a similar order may be passed in item number 55, hearing item number 55.
Okay, similar order.
Yes.
Yeah, please, Your Lordship.
Yes.
Lordship, I beg to mention item number 50 on behalf of my senior N. Kumar.
50.
Yes, Lordship. Lordship, since my senior is personal difficulties, kindly list this matter after a week.
On the prayer of Mr. N. Chishi, learned counsel for the respondent, listed after a week. Okay,
Obliged, Lordship.
I please, Your Lordship.
yes,
Lordship, I beg to mention hearing item 38, Lordship. The Lordship may be gracious if this matter can be listed after 2 weeks, Lordship. Here, the leading counsel, Mr. Ajo, is currently out of station because of some unavoidable
your
circumstances.
good
Lordship.
name,
V. Koza, Lordship.
V.
Koza, Lordship.
Mr. V. Koza. Learned counsel makes a mention on behalf of Mr. Azo, learned counsel for the petitioner, and seeks adjournment of the case after a week. Prayer is allowed, listed accordingly.
Much obliged.
May I please, the Lordship?
Yes.
Lordship, I beg to mention hearing item 42, Lordship. Earlier, this matter was handled by my colleague, Livika Simi, Lordship. However, just recently, the file is with me, Lordship, and I have to go through the brief, Lordship. So if Lordship may please gracious enough to list the matter after.
Mr. V. Jamomi, the learned government advocate submits that the file relating to the case has been handed over to him only recently. He would therefore request, he would therefore require some time to go through the file and to address this court. Listed after 2 weeks.
Hi, Lord.
May I please, Lordship.
Yes.
Lordship, I beg to mention item number 44. Lordship, in this case, earlier, Ms. Sangdi was appearing for the respondents, and she has already filed the affidavit also. But since she has not got her extension by order dated 27/5/2024, this court has requested me to appear for the respondents.
Okay.
So I have intimated to the respondents, but they, since till date, there's no intimation from them. This railway case, Lordship. And railway, usually they have their own standing counsel.
Let us see by which order.
For Lordship, may I see item number
This is
order
item number,
44.
okay, let us see the report. By which order?
27/5/2024.
27/5.
2024.
Have you communicated with the
Yes.
railways?
I did.
By the order dated 27/5/2024, passed by this court. Mr. Yamawati, the Unit CGC, was requested to obtain instruction from the railways, from the concerned railway department. Stop. Mr. Yamawati, Learned CGC submits that although he has written to the railway department to issue the necessary instructions in the case, Kumar, no instruction is forthcoming. Mr. Yamawati, Learned CGC accordingly submits that. He has difficulty in processing the case on behalf of the railway department. What to do now?
Lordship, a fresh notice may be issued to the railways. Lordship.
Stop. In view of the submissions made by Mr. Yamawati, Learned CGC.
Otherwise, Lordship, the railways, they have already filed their affidavit.
The learned counsel or the petitioner shall take steps, shall take fresh steps for service of notice upon respondent number 1 to 5 by a registered post with AD within a period of
2 weeks, Your Lordship.
2 weeks, within a period for service of notice
Lordship, 1 week, Lordship.
for within a period of 7 days from today, listed after 3 weeks.
Lordship. Lordship. May I please, Your Lordship.
Yes.
Lordship. In fact, mention item number 42, Your Lordship, for the petitioner, Your Lordship. 42, Your Lordship.
42 has been mentioned. 42. Did somebody mention 42? Yes. Yes.
Please, Your Lordship.
Hmm.
Lordship, I'd like to mention item number 29. Your Lordship, yes, Your Lordship.
As per the list.
Yes, Your Lordship.
As per the list. Let it come as per the list.
Okay.
Please, Your Lordship.
Yes.
I beg to mention hearing item number 45 and 49 on behalf of my senior. Lordship is on bereavement, so kindly list this matter after 2 weeks.
45.
Yes, 45 and 49.
The one by one. Your good name
Manan.
on the prayer of Mr. So-and-so, learned counsel. For the petitioner
Yes, Lordship.
listed after 2 weeks. Same order in item
49.
49.
May I please, Your Lordship.
Yes.
Lordship, with the consent from the other parties, I would like to mention hearing item number 56 and 57.
Ah,
I pray the matter may be listed after 2 weeks, Your Lordship.
on the prayer of Mr. I. Jamir, the learned counsel for the petitioner listed after 2 weeks.
Life.
For motion, item numbers 1 to 17.
May I please, Your Lordship. Lordship, the present IA is only concerned with the WPC 46 of 2023. And since all these matters are analogous, so it has been listed together.
You want to delete the name of the applicants from writ petition number 46/2023.
Lordship, they are petitioner number 7 and 15.
But Mr. Ayinko,
I, Jamir, Lordship.
Then the counsel for the applicant. The present application has been filed for withdrawing the names, for withdrawing/deleting the names of the present applicant as the petitioner number 7 and 15 in the connected writ petition number 46/2023. The applicants are allowed to withdraw as petitioner number 7 and 15 in the connected writ petition number 46/2023 at their own risk. I stands disposed. Okay.
Lordship, an order may pass it amend petition 46.
Yes. So
And I also pray for 3 weeks' time, Lordship, to reply to the counter affidavit filed by the respondents.
in WPC 46, okay. In view of the order passed in IA number 108/2024, petitioner number 7
And 15.
and 15 are deleted as the petitioner in the present writ petition. Stop. The learned counsel for the petitioner is also allowed 3 weeks' time to file reply to the affidavit in opposition filed by the state respondents
Lordship.
listed accordingly.
Obliged.
For admission, item number 18.
May I please, Lordship.
By this petition, the petition is challenging this termination order dated 30 January 2023. The impugned order is at page number 31. The petitioner was appointed on the basis of a recommendation made by the Departmental Selection Committee. However, while the petitioner was serving, it came the state government has issued another approval order for appointment of the private respondent number 4 against the post held by the petitioner on commissioner ground. And without serving any notice to the petitioner, he was terminated.
You were appointed on?
I was appointed on the basis of the recommendation made by the Departmental Selection Committee. The Departmental Selection Committee report is at page number. No advertisement, page 18. This recommendation has been approved by the state government.
But Mr. Limawabon, Learned Counsel for the petitioner. The case in brief is that the petitioner submitted the application dated nil to the Commissioner of Excise Nagaland Dimapur for appointment to the post of Chowkidar within bracket MTS under the Superintendent of Excise Oka. Stop. A screening committee was constituted by the department and the committee on 21/11/2022 recommended the petitioner to the post of Chowkidar within bracket MTS at Oka. Thereafter, by the letter dated 5 January 5/1/2023. The government issued the letter. No. Well, what was the last line? The government conveyed the approval for appointment of the petitioner to the post of Chowkidar MPS Oka. And subsequently by the order dated 7/1/2023 issued by the Commissioner of Excise Nagaland, the petitioner was appointed to the post of MTS in the office of the Superintendent of Excise Oka. Stop. However, by the letter dated 8/5/2023 issued by the government in the Department of Excise and Prohibition, Nagaland, Kohima, the respondent number 4 was appointed to the post against which the petitioner was appointed on compassionate ground. And consequent thereto, the Commissioner of Excise Nagaland Dimapur issued the order dated 30/10/2023 immediately revoking the appointment of the petitioner as MTS under the establishment of Superintendent of Excise Oka. Okay,
Yes, sir.
being aggrieved, the petitioner is before this court. Is before this court.
Worship, in interim period, notice may be issued in the interim period.
Issue notice to the respondents, returnable after 4 weeks. MS Inaholi appears on behalf of appears on behalf of the state respondent number 1, 2, and 3. Therefore, no formal notice need be issued. So the learned counsel for the petitioner shall however serve the requisite copies of the writ petition to the learned counsel for the state
Within 2 days.
within a period of 2 days from today. Insofar as respondent number 4 is concerned, the learned counsel for the petitioner shall take steps for service of notice upon the said respondents by a registered post with AD
Within 2 days.
within a period of 2 days from today. Stop. The prayer for interim shall be considered on the next return visit.
The next item is also similar. But here the petitioner submitted his application on 6/10/2022. Only that is the difference. Date of submission of
Same post,
post worship.
let us-
MD is only worship. Multitasking stuff.
MTS,
Multitasking stuff. Just view. Office peon.
yes. Application submitted on 6/10, okay? 6/10/2022. And this is for the, this is for the post of,
Office peon under the Commissioner of Excise.
for the, this is Atubu Miese.
Atupulos.
This is for the office of office peon within bracket MTS at
In the office of Commissioner of Excise.
in the office of the Commissioner of Excise at Dimapur.
Dimapur.
Okay. So insert that, okay?
For admission, item number 20.
May I please, Your Lordship?
Yes.
Your Lordship, I beg to mention on behalf of the counsel for the petitioner, Mr. Limatushi. Your Lordship, kindly grant 2 weeks to file affidavit in reply to the counter filed by the state respondents.
MS Censor, Learned Counsel, makes a mention on behalf of Mr. I. Limatushi,
Yes, ma'am.
the Learned Counsel for the petitioner, and seeks for 2 weeks' time to file affidavit in reply. Prayer is allowed. Listed upon.
There is no chairman. No.
The interim order pastor here shall continue till the next returnable date.
For admission, item number 21.
Please, your lordship. Your
Yeah.
lordship, here pleadings are completed, so if it may be listed for the hearing list.
What is this writ appeal? Writ appeal 35/2022.
Your lordship, this is with regard to retrospective regularization. This has been, an SLP has been filed here, your
Ah.
lordship.
What is the case in the writ petition?
The petitioner is seeking for retrospective regularization, your lordship. He was a work charge fixed pay.
Okay. It is submitted by the learned counsel for the parties that pleadings are completed. And the matter can be taken up for hearing. Stop listed for hearing in the usual course.
For admission, item number 22.
Yes, Mr. Solo.
Lordship, here the CGC, they are yet to file their affidavit, your lordship. As per the last order, your lordship.
CGC,
Lordship. The government, they have filed their affidavit, your lordship.
where's Mr. Yanawati? He was here. Mr. Inshallah, correct?
Lordship.
Appears for the petitioner, and Mr. E. Tibapong appears for the state respondents. None appears for the respondent number
13567, your lordship.
135. No,
One,
1567,
1567,
156 and 7.
lordship.
Listed after 3 weeks for enabling the learned citizen to file the affidavit in opposition.
Much lordship. For admission, item numbers 23 and 24.
May I please, your lordship?
Yes.
I'm appearing for respondent number 6 in WBC 221. Item number 24, lordship. I have received instructions, so I may be allowed 1 week time to file my affidavit.
6 in item number
Item number 24, lordship,
221.
221, lordship. Respondent number 6, lordship.
What about the 220?
Your lordship, state has filed the affidavit for 220 and 221 also.
In 220, why so many departments?
Your lordship, here, as per the meeting minutes, your lordship, various directions were given by the government, your lordship, to the department to submit proposal for accreditation, your lordship. for which this department certain included.
So you are for, you are for in
No.
220, you are for all the respondents?
Yes, your lordship.
All the respondents, and in 220, you have filed your affidavit,
Yes.
correct? Okay. Then 221, let me see what the part is. Two 21, madam, have you filed your affidavit?
Yes, your lordship.
221.
I filed for all the respondents except for respondent 6.
Why you are actually like omitting respondent number 6?
Lordship, I'm the standing counsel for respondent number 6, lordship.
In WPC 221 of 2022, MS Apila Sankam, the learned standing counsel for the Department of Social Welfare, Nagaland, Kohima, is allowed
1
to,
week, lordship. I have received already
is allowed
instruction.
2 weeks' time to file affidavit in opposition. Listed after 2 weeks.
Obliged, lordship.
For admission, item number 25.
May it please your lordship.
Yes.
Lordship, here the case of the petitioner is under consideration. So may I pray this matter be listed after 3 weeks so that I
So
will
what
be
is the
able.
case?
Your lordship, regulation as per the scheme, your lordship.
Regularization.
Lordship.
MS Esmer, the London Senior Government Advocate, submits that the case of the petitioner is under active consideration of the government. So, in view of the submissions made by the London Senior Government Advocate, listed after 3 weeks.
Lordship.
Obliged.
I'm obliged.
For admission, item number 26.
May I please your lordship. Lordship, I'm for respondent number 4 and 5. Lordship was gracious enough on the previous occasion, that is 5/7/2024, for granting me 2 weeks' time to file my affidavit in opposition, lordship. However, lordship, there are some necessary changes as well as some paragraphs needed to be added. So lordship may be gracious if.
Have you
1
filed
week-
your affidavit?
No, lordship. So lordship may be
What about
gracious.
the other respondents?
I have filed, lordship. Yes, lordship.
You have filed?
Yes, lordship.
You have for respondent number?
Appearing for respondent number 6, 7, and 8.
Sabong, you have for?
I'm for respondent 9. I have 5.
Mr. KP, you have filed your affidavit?
Yes, lordship.
Yes, lordship.
So only 4 and 5.
Lordship. Lordship, may grant me 1 week time, lordship.
Mr. So-and-so, Learned Counsel for the respondent number 4 and 5, is allowed 2 weeks' time to file affidavit in opposition, listed after 2 weeks.
For admission, item numbers 27 and 28.
Please, your lordship.
Hmm.
Your lordship, the WPC number 169 of 2023 is the item number 28. That is the removal of the petitioner from the post of chairman of the village council, your lordship, Yoruba village council.
And 388, 338,
That is subsequently again, he was removed from the post of VCM, which has been stayed by the Zound Court, your lordship. My lord will kindly appreciate the section 9 of the Nagaland Village Council Act 1978. There is a procedure to be followed for the removal of a member, whether he is a chairman or a VCM. Both of them are members, your lordship. Now, as members, there is a procedure to be followed, and if we go by the section 9, clause 1F of the Nagaland Village Councils Act, 2/3 of the majority is to vote against a person to be removed as a member, as a village council member or as a village council chairman, your lordship. And that has been decided in a catena of decisions of this honorable court also, your lordship. As far as the first point is concerned, no procedure of law was followed to remove him just because somebody had developed some kind of decency against the present petitioner. The dissenting party, they put up a complaint before the ADC Chozuba, and subsequently he was removed by the deputy commissioner. But if we go by the precedent set by this honorable court, it should first be the decision of the village council, where no such decision is present, your lordship, in this case. My lord, secondly, as my lord has already understood, the 2/3 majority was not there to remove him, just a simple majority, your lordship. And 9(1)(f) is clear that it should be 2/3 majority. And there are 6 grounds under which a person
How many
can be
members are
removed.
there? How many members are there?
There were actually 21.
21.
But 2 passed away.
Okay,
And
so
so 19.
Okay.
Out of 19, 11. So, your lordship,
Out of 19,
11. 11
what?
11 members dissented against the present petitioner.
2/3 of 19 will be?
19 will be 12 point something, your lordship, because 18 will be 12, your lordship. Now, my lord, here again, if we go by the 6 grounds under which a person can be removed, my lord, whether any of those grounds, whether he has the issue of the corruption or issues with moral turpitude, whether he is of unsound mind, whether he was not present when the village needed him for the village development purposes, your lordship, and for the welfare of the village, none of those grounds were proved against him. It is just that the present petitioner tried to go against a particular respondent who is also the private respondent, your lordship. He had taken into his personal account the village money, your lordship. So when such complaint was made against a person, then he led a group of the persons to go against the present petitioner, your lordship, and there was a dissenting group led by the present private respondent, your lordship. If we go by the interpretation of law, my lord, there was no ground to remove him as the chairman of the village council, also as a member of the village council, your lordship. Basically, that is the law, my lord. I mean, that is the case.
Mr. Nangami, what is your stand?
Lordship, the government has in fact applied the rules that are prescribed under the Act to remove the petitioner as not only as village council chairman under section 9(3) of the Act, but under section 9(1)(f) of the Act. The government has acted on it and removed the petitioner as village council members as well, your lordship. Now, your lordship, the petitioners, my learned friend here has submitted that there were 21 members, village council members, which is incorrect. Actually, there were only 11 village council members. It is there he has annexed it as one of the annexures, the lordship. Now, on a meeting that was held, where a decision was taken to remove the petitioner as a village council members, 7 of the village council members were present and voted against the petitioner. That comes to 2/3 majority, your lordship. So all the rules has been applied, your lordship.
That is a wrong interpretation, your lordship. It is in their own
Let's
document
see,
that there are
let's see the
21 members.
VC Act, let's see the VC.
Your lordship. But since my learned friend has already made that submission, may I take your lordship to their
Let me first see the.
own affidavit, your lordship.
Let me first see the VC. Village Council. You were mentioning section 9,
1F, my lord.
1.
In fact, my lord may kindly appreciate starting from A.
What?
These are the grounds.
I was referring 91F because your lordship, he was, my learned friend was talking about the 2/3 majority, your lordship. That is reflected in 91F, my lord.
All the grounds will have to be appreciated, my lord. Yes, it's not just one ground under which a person can be removed.
Your lordship will find the total number of the village council members.
So this 1/3, this 2/3, whether it will be applicable for clause A to E,
Your lordship,
whether this clause F, which prescribes a 2/3,
yes, your lordship.
will be applicable for clause A to E.
Yes, my lord.
It's
Because
applicable
this,
2/3.
yes, your lordship, it's all the grounds that has to be considered, your lordship. But this is the nature on which Nagaland makes laws, my lord is fully aware. And my lord, the interpretation of my learned brother is, it's erroneous in the eye of law for a fact that all the GBs have voting right, your lordship. So it does not say village council members, it says members. All of them have the voting right. So it's not just the village council members, your lordship.
So you mean to say that GBs should also be included in the 2/3?
Yes, your lordship, they all have the voting right. They have the right to vote, to either elect or to remove, your lordship.
Let us see which provision impose the GB to vote.
Your lordship.
Which provision?
Lordship, the section 4, your lordship. A village council shall consist of members chosen by villagers in accordance with the prevailing customary practices and usages, the same being approved by the state government, provided that hereditary village chiefs, GBs and ANGs shall be ex officio members of such council and shall have voting right. So they are also members, ex officio members with voting rights.
So what would be the total number of the members, including the GBs?
Your lordship, 21, my lord.
Why the difference in the number? You're saying
Lordship.
21.
Yes.
You are saying
11, your lordship, 11.
It's a gap of 10.
Yes, your lordship, section 4, if I may be allowed to read, your lordship.
Let us see the notification issued by the government.
Lordship, at page 42, annexure 2 of the writ petition, my lord. These are the selected list of the VCM,
42
my lord,
of the writ petition.
of the writ petition, my lord. Your Lordship, the type copy is available at page 44.
42 of the writ petition in which,
In the 169, WPC 169, my lord.
what is 169?
Removal of the petitioner from the village council chairman.
Chairman post, Your Lordship.
May I read, my lord?
No, not this, not this. You are actually on 41. You are on page 41.
Page 42. Page 42, my lord. Approval of newly elected, selected village council members, Your Lordship, VCMs. And the name of the petitioner village, Your Lordship, is as on the next page. It is Yoruba village. Yoruba village. Your Lordship will find there are 11 members.
Yes, Mr. Joshua,
Your
as per
Lordship.
the approval of the government, there are only 11 members.
Your Lordship, this is the village council members. This is the village council members. It should not be confused with members, Your Lordship. Members, the GBs, they are also members, Your Lordship. Then what's the point of the GBs of the voting right, Your Lordship? So in my respectful submission, that is a misleading.
How many GBs?
Your
How
Lordship,
many GBs Yoruba village has?
if the number 21 is to be taken into consideration, Your Lordship, there were 10, out of which two of them
10
passed away, Your
GBs.
Lordship.
10
Yes, Your Lordship.
GBs.
Yes, Your Lordship. Two passed away. No, Your Lordship, for a time being, not admitting, because respectfully, that is a misleading submission, but even assuming that what my learned brother is saying is correct, on what ground can a person just be removed? Just because somebody has a majority, whether it's a simple majority or absolute majority, Your Lordship, on what ground can a person be removed? And the grounds are specifically, it's very specific, Your Lordship. It's pointed out on what grounds a person can be removed. Now, if because somebody has a simple majority or absolute majority, if they are given the opportunity to throw away anyone, my lord, the rule of law in the village will be lost. The rule of law will be defeated.
What was the reason for removal?
Your Lordship, the petitioner has misappropriated the village council fund, which the petitioner himself has admitted.
Document doesn't show that, my lord. That is very misleading. Very
Lordship, I have
unfortunate.
annexed it.
That's
I
a
have
very
annexed it. Not
unfortunate
only that,
submission, Your Lordship.
not only that, Your
My
Lordship,
lord.
not only that, Your Lordship, the petitioner has submitted a false allegations letter addressed to the Honorable Deputy Chief Minister, a copy of which was endorsed to the Chief Secretary as well as to the Commissioner, Deputy Commissioner.
What was the allegation?
The allegation was, Your Lordship, the ADC Chozuba is acting at her own whims and fancies. That was the allegation, and it was the complaint letter was on the writing pack of the Chagasan, not Chagasan, Chozuba Range Public Organization letters writing pack, wherein in that particular letter, complaint letter, the chairman, president, and general secretary of the Chozuba Range Public Organization, as well as the chairman of the Chozuba Area Village Council Chairman Union, as well as the Chozuba Area GB Union, was made to sign by misleading them, Your Lordship. By misleading them. Thereafter, Your Lordship, the Chozuba Range Public Organization has already submitted a letter stating that that was done completely at the behest of the petitioner. Not only that, the Village Council, the Chozuba Area Village Council Union also has submitted a clarification letter to the Chief Secretary stating that it is at the behest of the petitioner that the chairman has signed that particular letter. It was not done under any consultation whatsoever. I have annexed all those in my affidavit in opposition, my lord. So, your lordship, the issue whether he was guilty of any misconduct or the issue whether he has conducted any disgraceful conduct or not, your lordship, it was proved beyond reasonable doubt. And therefore, your lordship, on the termination order itself, it was clearly mentioned that he has been removed as a member of the village council, or as a member of the Yoruba village council under section 91F.
Your lordship, if my brother is making a mountain out of a molehill, let us go document by document, your lordship. There is nothing to dispute here. The plain submission made by my learned brother without relying on the actual document, the genesis of the matter is how it started is that 13 lakhs were misused by transferring the same into the personal account of the private respondent, and the complaint was made against him. Another issue is that the VDP money was misused. Initially, the present petitioner also, he did not know, but later on he came to learn that few crores were misused, and the VDP secretary, the then VDP secretary, is already in jail, your lordship, for that. Now, when the complaint was made against the present private respondent, that's when the issue blew out of proportion, knowing fully that the 13 lakhs amount was transferred into the personal account of the present private respondent. The additional deputy commissioner, the then additional deputy commissioner, refused to take any action. So naturally, a person would write a letter against a person that the person has taken law and order into the whims and fancies of the person concerned, your lordship, the official concerned. Now, that is not a subject matter of dispute. And on that ground, how can a person be removed as the chairman, your lordship? Or for that matter, even as a village council member, my lord. So if we go document by document, it will take some time, your lordship. If my lord has some time, then we'll go document by document. And I will prove before this honorable court that this is not an imaginary case. It is not a case of dispute of facts and evidence, but it's a clear case that he has been illegally removed from the post of village council chairman as well as the village council member, my lord.
Okay, heard Mr. Joshua Chapman. Then counsel for the petition. Mr. N. Angani, learned senior government advocate for the state respondents. And MS Sonso, learned counsel for the respondent number 6. Listed as a fixed item for hearing.
Admission hearing, my lord.
On when a date is given, it's over.
My lord.
On 6/8/2020. We'll hear on 6/8/2020.
Blush, your lord.
Deeply obliged, my lord.
For admission, item number 29.
Please, your lordship.
Yes.
Your lordship, I have instruction to withdraw this present rate petition, your lordship, since the parties are agreeing to amicably settle the matter.
Okay, if you are the counsel for the petitioner,
Yes, your lordship.
Mr. Senso, learned counsel for the petitioner submits that he has instructions to withdraw the writ petition
Your lordship, I may be allowed to withdraw with liberty to
with
approach the
liberty to
present
file
court in the
afresh.
event of.
With liberty to file afresh. Where is allowed? Writ petition is allowed to be withdrawn with liberty to file afresh.
For admission, item number 30. 30.
30.
May please lordships.
Yes.
Lordships, I'm making mention of behalf of the leading counsel for the petitioner, Lordship Mr. Ankit Todi. Lordship is out of station for some medical checkup. So if Lordship may kindly be gracious enough to give me 4 weeks, Lordship.
Mr. Fuseko, the learned counsel, Mr. Fuseko makes a mention on behalf of Mr. Ankit Todi, the learned counsel for the petitioner, and seeks adjournment of the case for 4 weeks on the ground that the learned counsel for the petitioner is out of station. There is allowed, listed after 4 weeks. Mr.
Lordship, A.K. Mishra is special PP.
Mr.
A.K. Mishra,
A.K. Mishra,
special PP of Union of India. Sir.
Special PP for the Union of India. appears for the respondents.
Lordship is an interim, kindly didn't continue, Lordship.
Yes,
So the interim order passed earlier shall continue till the next written evidence.
For admission, item number 31.
May it please my lord,
Yes.
I'm here to receive instructions. So may I pray that 3 weeks time may be granted.
What about Mr. Yangarawati?
I was similar there.
You are appearing for union.
Yes, sir.
What is the matter, Mr. Lima?
Here the petitioner's lands were taken away for construction of the National Highway 2 without acquiring their land. So the petitioners are looking for compensation, land compensation. Worship, there are 11 analogous matters, starting from WBC number 96 of 2024,
WPC 96.
96 of 2024 to 106 of 2024.
96.
Altogether, we have filed the 12 rate petitions. So all the 12 rate petition may be listed together.
Mr. LT Something, learned additional AG for the state, as well as Mr. Yangarawati, learned CGC, are both allowed 3 weeks time to file counter affidavit, to file their respective affidavit in opposition. Stop. Mr. Limawawang, learned counsel for the petitioner, submits that the present writ petition is analogous to writ petition WPC 96/2024. And accordingly submits that the present writ petition may be tagged with WPC 96/2024. Prayer is allowed. Take the present writ petition along with WPC 96/2024.
Worship, not only the WBC 96 of 2024, from 96 to 2024 to 106 of 2024.
It's all right if one is mentioned.
Yes, sir.
For admission, item number 32.
May I please, your lordship? Your lordship, kindly grant me 3 weeks time to file my affidavit. I'm here to receive the parawise convention.
MS, AIMB, Learned Common Advocate is granted 3 weeks time to file affidavit in opposition.
For admission, item number 33.
Yeah, please, your lordship.
Yes.
My lord, I'm yet to receive instructions, so kindly allow me 3 weeks time. My lord.
Okay.
Objection, Lord.
Mr. E. Tibako, non-government advocate, is allowed 3 weeks time to file affidavit in opposition on behalf of the state respondents.
Much obliged.
From the supplementary course list for admission, item numbers 59 and 60.
Yes.
Yes, Your Lordship. Lordship, I'm appearing on behalf of my senior. Lordship, he is on bereavement. So if it can be fixed on Friday.
Yes, Ms. Esmeri, what is the matter? Why it has-
The petitioner is praying for regularization of scheme, of work charge employees, Your Lordship.
Mr. Sensor, then the council submits that. Who is your senior?
Mr. Sindiangar.
Mr. Sidi Amar, the London counsel for the petitioner is in bereavement and therefore seeks adjournment of the case on one. 1/8/2024. That is all listed.
Obliged, Lordship.
For orders, item numbers 34 and 35.
Yes.
May I release your lordship?
Yes.
Lordship, I pray for a few days adjournment for review, that item number 34. Within this week or any day on the next week. And in item 35 is a connecting matter. I'm yet to receive an instruction.
Lordship, steps have already been taken in respect of respondent number 3.
Who is respondent number 3?
Nagaland Public Service Commission, NPSC, Lordship. Lordship, in the earlier case, this case was listed in admission list, but today it happens to be in the order stage.
The only question is whether this court will allow the review. That's
Yes,
all.
Lord. Yes, my lord.
So no need affidavit.
Yes, Lord.
No need of your affidavit will be in the main writ petition.
Yeah, not in the review.
But insofar as
Yes.
review is concerned, the only issue is whether the review
Yes,
will be
your
allowed.
lordship, yes. So your
But the
lordship,
petitioner has to satisfy this court.
yes, your lordship.
So when can we fix it?
Monday, Lordship.
Monday?
Yes, my
Okay. On the prayer of Mr. So-and-so, then a counsel for the petitioner, listed again on, what is Monday?
Date 5, Lordship.
Fifth.
Okay, listed again on 5/8/2024.
Obliged, Lordship.
For orders, item number 36.
May I please, your lordship.
Yes.
Lordship, by order dated 25/4/24, lordship. 25/4/24. Lordship, I was allowed to take dusty service upon respondent number 9. (25/4/24), lordship.
Yes.
Lordship, so I have taken dusty steps, lordship, and I have filed my affidavit on 8/7/24, lordship. Dusty affidavit.
Who is respondent number 9?
Lordship, it's the village council, lordship.
And your case is about?
Lordship, here, this pertains to construction of 2-lane road, lordship, land acquisition in the district of Peran, lordship.
By the order dated 25/4/2024, the London counsel for the petitioner was allowed to take fresh steps upon the respondent number 9 by dusty process and to file affidavit to that effect. MS Lucino, learned counsel for the petitioner, submits that the order dated 25/4/2024 has been complied with, and affidavit dated 8/7/2024 has been filed to that effect. Service of notice, stop. Service of notice upon the respondent number 9 is accordingly deemed set. Yes,
Lordship, I also pray for 3 weeks' time to file my reply to the affidavit filed by the respondent number 1, 2, and 3, Lordship.
state.
No, the NHIDCL, Lordship, the union.
What about
My
you?
lord, I'm appearing on behalf of respondent number 4 to 8.
You have filed your affidavit.
Yes, my lord.
You
I'm
filed
not-
your-
No,
not
Lordship,
yet.
they are yet to
I'm
file,
yet to
Lordship.
receive instructions. May I pray that similar order may be passed.
Lucino, the learned
3 weeks
counsel for the petitioner is allowed 3 weeks' time to file affidavit in reply to the affidavit in opposition filed by the respondent number 1, 2, and 3. Stop. Mr. L.T. Santam, the learned additional AG is also granted 3 weeks' time to file affidavit in opposition on behalf of the state respondents. Listed accordingly.
Much obliged, Lordship.
For orders, item number 37.
May I please, your lordship?
Yes.
Lordship, as per the last order, your lordship, the service upon respondent number 6 was still awaited, your lordship. And the action was given to put up, check the service of the notice, your lordship.
Who is R6?
A private respondent, your lordship.
Okay. Seeing the office note dated 21/6/2024. Stop. Service upon respondent number 6 is accordingly deemed set. Yes.
Your lordship,
Did
we are
you
yet
file your
to,
counter,
no, not yet, your lordship. We yet to
Mr.
receive instructions.
Mr. So-and-so? The learned government advocate submits that he is yet to receive instructions and therefore seeks for 3 weeks' time to file affidavit in opposition. Fair is allowed, listed up to 3 weeks.
Much
obliged.
For hearing, item number 43.
Yes, what is the matter?
The petitioner who was who is a Assam Rifle person. What happened is that he was discharged under allegation that he had incurred 4 great increase money. What are the 4 great entries? Are for page 16 of my writ petition. So, my lord, show cause notice, you were enrolled as recruit sergeant such on 19 September 2007 in Assam Rifles. Thereafter, in your service of 7 years, 11 months and 14 days, as on 3rd September 2015, you have incurred 4 rate entries in your dossier. The details of the offenses are as under. Serial A, Assam Rifle A, Section 26, Clause B, date of offense 1 October 2011, statement of offense without sufficient cause overstaying leave granted to him. Then what was the punishment? Punishment awarded was 28 days RI in Assam Rifle custody. Then B is section 26A, 27 February 2015, absenting himself without leave. 70s RI in Assam Rifle custody. Then C is section 35, 2nd March 2015. Intoxication, 70s RI in ER custody. D, section 35, 16 June intoxication, 28 days in Assam Rifle custody. So the petitioner, being illiterate, he filed this reply, page 17. Prayer for apology.
You have admitted?
My lord, I'll come to that, yes. So what happened by 4th October 2016?
Read this, page 17.
17. Most humble and respectfully, I would like to state the above cited subject in the esteemed embarrassment for my own self-deed that I had failed to perform my duty sincerely as per the services do. During the past day of my services, therefore, I would like to beg you, kind authority, to kindly accept my apology and reconsider me to continue my services, to which act of your kindness, kind consideration, I will perform my duty as per the service norms, as in the interest of my superiors.
What is the operative portion of page 16? You should submit your reply to this show cause at the earliest but not later than 20. Okay.
So, my lord, the whole question is that all this punishment, see that I am guilty as charged, and I'm already punished.
The same thing, just excuse me for 2 minutes.
My lord. Itu lalu. section 97 difference untuk para ahli. How these punishments were awarded, my lord. My lord, there was no procedure was followed, Tito. First thing is that, yes, the commandant is the authority for giving a punishment. There are General Assam Rifle Corps, PT Assam Rifle Corps. The last is the summary Assam Rifle Corps, which the commandant is the full authority. But the procedure, as per the laid down procedure, all the procedure have to be followed.
What is the procedure prescribed?
My lord, that is, as per the rule, particularly.
Have you annexed the rules?
No, my lord.
Under which rule procedure has to be followed?
My lord, chapter 12, summary Assam Rifle Codes. Rule 144 is proceedings. The officer holding the trial herein after referring this chapter called the court, that is summary Assam Rifle Code, shall record or cause to be recorded in the Hindi or English this transaction of every summary Assam Rifle Code. First. Two, the evidence shall be taken down in a narrative form in as nearly as possible the words used, but in any case, where the court considers it material, the question and answer shall be taken down in verbatim, like any other court, even in civil or in criminal. That evidence is to be accused for any punishment. Rule 145 is evidence when to be translated. When any evidence.
What is the procedure to be followed when the allegation is admitted?
No, I'll come to that.
When there is admission?
Yes. 153.
What is the book you are referring?
This is Assam Rifle Rules of 2010.
Whether we can get that book in the library? Yes.
Page 226.
Page
226. It is just same as the criminal procedure. Rule 153, general play of guilty or not guilty. The accused person's play of guilty or not guilty, or if he refuses to play or does not play intelligibly, either one or the other, a plea of not guilty shall be recorded on his side. Subrule 2, if an accused person pleads guilty, that plea shall be recorded as the finding of the court. Yes, it has to be recorded as the finding of the court. But before it is recorded, that is
You are
the
reading a rule?
Rule 153. So take it that the petitioner pleads guilty. One five three, subrule 2. My lord, can I have the book? It may be different from mine. But rule is said, indeed that.
This is Assam Rifle Rules 2010.
My lord,
And you are referring to rule?
153. It's same as in the criminal procedure. If somebody plays not, which is not intelligible, then it is to be recorded as not guilty. That is subrule 1. 2, if an accused person pleads guilty, see that the petitioner pleads guilty, then that plea shall be recorded as finding of the court. But that is the condition. But before it is recorded, the court shall ascertain that the accused understands the nature of the charge to which he has pleaded guilty, and shall inform him of the general effect of the plea, and in particular of the meaning of the charge to which he has pleaded guilty, and of the difference in procedure which will be made by the plea of guilty, and shall advise him to withdraw that plea if appears from the summary or abstract of evidence, or otherwise that the accused ought to plead not guilty. Then subrule 2. When accused pleads guilty, such plea in the factum of compliance sub rule 2, that is, you shouldn't have plead guilty or the consequences of this rule shall be recorded by the court in, this is the rule.
I think you please read this 153 again. 153. 153.
General plea of guilty or not guilty. Sub-rule 1 is accused person plea of guilty or not, or if he refuses to plea or does not plea intelligibly, either one or the other, a plea of not guilty shall be recorded. Then, next, just see that somebody don't understand because
Just read. It's all right. Read. I have understood.
Oh, yes, my lord. Sub-rule 1, the accused person's plea of guilty or not guilty. Or, next is, if he refuses to plead or does not plead intelligibly, either one or the other, a plea of not guilty, like in the criminal proceeding, shall be recorded on each charge. Because the whole proceeding was in English, the petitioner is not an illiterate person. So whatever they were proceeding, the petitioner don't know. Sub-rule 2 is, if an accused person pleads guilty, yes, that plea shall be recorded as the finding of the court. But that is the condition before it is recorded. The court shall ascertain that the accused understands the nature of the charge to which he has pleaded guilty and shall inform him of the general effect of that plea, and in particular of the meaning of the charge to which he has pleaded guilty, and of the difference in procedure which will be made by the plea of guilty, and shall advise him. Even if somebody
Continue. Don't cut.
to withdraw, he shall be advised to withdraw that plea if it appears from the summary or abstract of evidence or otherwise that the accused out to plead not guilty. Then sub-rule 3, my lord. As I've said that the petitioner is an illiterate person, the proceeding was in English. Then sub-rule 3, what does it say? Where an accused pleads guilty, such plea in the factum of compliance of sub-rule 2. C. Without there is any consequence to the pleading of guilty, shall be recorded by the court in the following manner. So, just see that the petitioner pleaded guilty, but this is the rule. So that before recording the plea of guilty of the accused, the court explained to the accused the meaning of the charges, English numeral, English words, to which he had pleaded guilty, in ascertain that the accused had understood the nature of the charges to which he had pleaded guilty. The court also informed the accused the general effect of the plea in the difference in procedure, which will be followed consequent to the said plea. The court, having satisfied itself that the accused understand the charges in the effect of his plea of guilty, except in record the same, the provision of Rule 152, 53, sub-rule 2 are thus complied with. That is the condition.
Then 154, is it relevant? Procedure after plea of guilty?
My lord, just say that if I pleaded guilty,
No,
Then
if,
first-
just, Mr.
yes,
If you have pleaded guilty, correct?
yes,
Assuming you have pleaded guilty,
yes,
154, the procedure prescribed under 154 has to be followed.
my lord.
So what is the procedure prescribed?
My lord, then
54, 154.
what I'm trying to see is,
I have understood.
yes.
I've
okay,
understood,
okay,
but
okay.
let me also
My
try
lord,
to understand.
Procedure after plea of guilty,
Ha.
sub-rule 1. Upon the report of the plea of guilty, if there are other charges in the same charge sheet to which the plea is not guilty, the trial shall first proceed with respect to those charges, and after finding out the charges shall proceed with the charges on which a plea of guilty, that is, which is not admitted, will be tried first. And after the finding of two charges, shall proceed with the charges on which a plea of guilty has been entered. But
So first, the court will proceed to those charges which has not been admitted.
not admitted. Yes.
Okay.
After the finding on two charges, then shall proceed with the charges on which a plea of guilty has been entered. But if there are alternative charges, the court may either proceed with respect to all the charges as if the accused has not pleaded guilty to any charge, or may, instead of trying him, report a finding of guilty upon any one of the alternative charges to which he had pleaded guilty in finding of not guilty upon all other alternative charges. Then, sub-rule 2. After the record of the plea of guilty on a charge, if trial does not proceed on any other charges, the court shall read the summary or abstract of evidence. That is just like in police, before the police evidence collected, and annexing to the proceeding. Or if there is no such, the court shall take and record sufficient evidence to enable it to determine the sentence. And for the reviewing officer to know all the circumstances connected with the offense. The evidence shall be taken in like manner as is directed by these rules in the case of plea of not guilty. 3. The accused may, after such evidence has been taken, or as the case may be, the summary or abstract of evidence has been read, address the court with reference to the charge, and in mitigation of punishment, and may call witnesses as to his character. 4. A. If from the statement of the accused, or from the summary of evidence, or otherwise, it appears to the court that the accused did not understand the effect of his plea of guilty. So in each proceeding, can the petitioner understand anything? No. The court shall alter the record in interplay of not guilty and to proceed with the trial accordingly. Any alternative charges withdrawn under sub-rule 1 shall be reinstated in the charge in the trial shall take place as if they had never been withdrawn. 5. If a plea of guilty is recorded on some charges in the trial proceeds with respect to other charges in the same charge sheet, the proceeding under sub-rule 2 and 3 shall take place after the finding and the other charges in the same charge sheet are recorded. 6. When the accused states anything in mitigation of punishment, which in the opinion of the court requires to be proved, would it prove affect the amount of punishment, the court may permit the accused to call witnesses to prove the same. My lord, what I'm trying to see is this. The proceedings of these all 4 proceedings, because as your lordship, that the highest court, that is in the military, this court martial, general, petty, and summary. So any aggravating punishment lies with the General Assam Rifles Court in Petition. So the Act provides under section 62 Section 62 is minor punishment, my lord.
Section 62
of the Assam Rifle Act 2006. that is. Before that, I may be allowed to come to the beginning of the chapter, that is chapter 5, page 19. Section 57, punishment awardable by Assam Rifle courts. Section 57. Subsection 1, punishment may be inflicted in respect of offences committed by persons subject to this act and convicted by the Assam Rifle courts, according to the skill following, that is to say, number 1, death, the imprisonment which may be for the term of life or any other lesser term, but excluding imprisonment for term not exceeding 3 months in forced custody. Dismissal from service, compulsory retirement, imprisonment for a term not exceeding 3 months, reduction to rank or to a lower rank, then G, forfeiture of seniority, X, forfeiture of service for the purpose of increased pay, I is fine, G is severe reprimand, which is only to the question of severe reprimand or reprimand, except in the case of person below the rank of under officer, that is the petitioner with the referment, not included. G, forfeiture of pay and allowances for a period not exceeding 3 months for an offense committed under D2. L, forfeiture in the case of person sentenced to dismissal from service of all areas of pay, allowances in other public money due to him at the time of such dismissal, stoppage of pay and allowances until any proof, loss or damage occasioned by the offense for which he is convicted is made good. Then each of the punishments specified in one shall be deemed to be inferior in degree disciplinary punishment proceeding in the above scale. So alternative punishment awarded by the Assam Rifle Court is as specified in section 21 to 54. That is,
Why are you reading all this?
Malo,
Why are you reading all this?
Malo, what
What
I'm-
relevance has it got to your case?
Malo, what I'm trying to see is the punishment, so-called punishment, are all minor. Then the whole proceeding is under rule section 63, 62, my lord. 62, I may be allowed to read out.
Yes, Mr. MT, you are confusing this court more and more. Just explain why are you referring to all these provisions?
My lord, what I'm trying to see is this. The petitioner is a leading person. In their saying that you are guilty of this punishment. Was the procedure followed? No. Then what I'm trying to see is this. The set for punishment, my lord, are all minor punishment because it is awarded by summary assessment, which is the lowest in the hierarchy of the courts. Then what happens is
How do I know that this is awarded by the summary court? How do this court know? This order, your order
yes,
4/10/2015, this is a punishment awarded by the Office of the Inspector General of Police, Inspector General of Assam Rifles.
my lord, but the proceedings.
So whether the Inspector General of Assam Rifles is the lowest court?
No, no.
I'm confused with this. That's why.
Then summary Assam Rifle Court is the commander.
But this punishment is awarded by the Inspector General of Assam
My
Rifles.
lord, for punishment by the commandant, my lord. All these four punishment was by the commandant. But the show cause in discharge is by the Inspector General because he is the authority for discharge.
See, Mr.
As per your
Mr.
lordship,
MT, see,
Yes.
the show cause notice was issued by a brigadier.
yes. But the punishment, I may be allowed to take your lordship to my learned friends affidavit.
No,
in-
let me forget about the pleadings. Let me first understand the case.
Yes,
Let me understand what is a summary court martial, what is the lowest court, what is the highest court. You are not actually explaining those. You are saying that actually, like, since the order was passed against the petitioner by a summary court martial, that is the
My
lowest
lord.
court. This, dismissal from service, discharge from service could not have been awarded. I'm confused.
my lord,
with your submissions.
as your lordship has pointed out, kinds of Assam Rifle courts is given in chapter 8, section 86.
Now, you first satisfy this court. Who has given the warning? Who has given the show cause? Who has given the order dated 4/10/2015, like discharging you from service?
My lord, it is by the IGV. Because that is the competent authority. Commandant of the authority to discharge any person. So it is the IGB in above who can discharge a person. So your lordship is
Whether the punishment was awarded in a summary court proceeding?
yes. Yes.
How do you justify that?
My lord, that is in my learned friend affidavit in opposition, which was never furnished to the petitioner. He brought it in the form of that one. Page 22 may be seen, my lord.
Page 22
of the affidavit in opposition of respondent 1, 2, in 3.
Mr. MT,
My lord.
You make it very clear before this court.
My lord.
Which court of Assam Rifle awarded this punishment?
To me, it is summary. Summary Assam Rifle Court. That is the command.
Whether actually like anything is noted to that effect in the order passed in the warning summons passed by the Assam Rifles?
My lord, the documents they have annexed in the affidavit in the opposition, I may be allowed to take your lordship to page 22. Page 22
of
affidavit in opposition of respondent 1, 2, and 3. I have received it on 11/4 of 2022.
Page
22. Lordship will, yes, will be clear with that. Page 22, form for use a summary proceeding of under officer in other enrolled person. We come under enrolled person under section 62 of the Assam Rifles Act of 2006. So,
okay, what is the punishment which can be awarded by the summary court martial?
my lord, imprisonment in forced custody up to 28 days. That is.
Where are you reading from?
My lord, section 62 of the Assam Rifle Act. The proceeding is very clear that under section 62. So, section 62, I may be allowed to read it, my lord. Or page 22, to be more clear, form for the use in summary proceedings of under enrolled person under section 62 of the Assam Rifles Act 2006. So the proceeding itself is clear. So I may be allowed to read out the section 62.
Mr. Yangarwati, most of your documents are ineligible.
Lordship, if my lordship may see the record branch instruction, then everything will become clear, Lordship.
Page,
In my affidavit, Lordship, additional affidavit, Lordship. My additional affidavit. Lordship. Page 2 of the additional affidavit.
yes,
Para 3, Lordship. That this additional affidavit is filed to bring on record the provisions, that is, record office instruction 4/99, wherein provisions has been provided to discharge a person who has entered 4 or more red ink entries in his service dossier. Instruction number 6 provides for discharge, disposal of undesirable person / inefficient personnel, which read as follows. Chapter 8, Rules 24 of the Assam Rifle Manuals invests powers to the Commandant of Assam Rifles Battalion to dismiss or remove any number of the Assam Rifles below the rank of Naib Sudar. This power may be invoked by the Commandant. This is very important, Lordship. Where a person has 4 or more red ink entries. In case it is necessary to send an individual on discharge under this provision, a notice will be served on the individual to give opportunity to explain his case. No. So, Lordship, the Commandant, he has.
where is this chapter 8, rule 24, Assam Rifle Manuals?
Assam Rifle Manuals. Assam Rifle Manuals. Lordship, I don't have a copy of the manual as of now.
This is the para you are relying, and then you don't have a copy of the manual.
Lordship, if my lordship may come to page 13. This is type copy, Lordship. Page 13. Record office instruction number 4/99.
Page 13 of?
13 of additional affidavit.
I am on page 13.
Yes.
Compulsory discharge?
No, Lordship. Type copy. Additional affidavit, Lordship. The additional affidavit.
Additional affidavit.
Page 13. Type copy.
Restricted?
Yes, restricted. That is page 13. Record office instruction number 4/99. Procedure for discharge retiring from service Assam Rifle personnel. Then instruction 1, Lordship. A comprehensive instruction.
I am not getting it. You please give him page 13. Let him see. Everything is solved. Page.
Start from 12. Restricted, Lordship. record office instruction number 4 of 99, procedure for discharge / retiring from service, Assam Rifles personnel. Instruction 1. A comprehensive instruction containing all existing order on the subject have been compiled in this form of this record of instruction for guidance and strict compliance of all concerned. Then instruction 6, Lordship. Page 15. Discharge. Disposal of undesirable inefficient person. So under this record of instruction, once a personal get 4 red entries in his service record, he can be discharged. But before that, a notice has to be issued to him, which was done, and thereafter he was discharged by the competent authority, that is DIG.
What was the proceedings in which this man was discharged? What was the proceeding? General court martial, summary court martial, or?
It was a summary because
Then under summary court martial.
under the record of instruction, it says that once a person,
Say, Mr. Yamarwati, if you see section 26, 62, 1622 does not provide for punishment of discharge. And your record of instruction cannot go against the act.
Lordship, under 62, the summary proceedings was held under 62, where the personal was tried 4 times. So on the basis of the section 62, he was awarded 4 red entries. Now immediately after he got 4 entries.
Section 62 provides only for minor punishment.
My lord, that is why he was given only minor imprisonment under section 62. That is 28 days, first, second, 7 days, third, 7 days again, and on fourth, 28 days. Rigorous imprisonment, that is under section 62. So, since he has got 4 red entries, so the record of instruction come into play, where it stated that once a personnel get 4 red entries, he shall automatically stand discharged after giving a notice.
So he has been punished under section 62 4 times.
4 times, yes.
And since he was found incorrigible.
4 times.
Show cause notice was issued.
Show cause notice was issued, and thereafter it was discharged from service. My lordship, may allow me to read para 16 of my.
No, let me first understand. I am still not able to understand this case. Let me understand, then only I will be able to properly hear you. These are the original record of instructions.
Hello.
Original record of instructions.
Page 13, 12, lordship.
12.
Yes, yes. The original start from page 5. The page 12 is a type copy only. The original is not very clear.
Yes, Mr. MT, come, let us first understand your case. I'm still a little bit.
So, my lord, it is not in dispute about the minor punishment as your lordship had understood in the proceeding itself is clear under section 62. And in the show cause notice, no documents were included. Page 16 itself is clear. Show cause notice. Show cause notice should have accompanied with their affidavit in opposition documents, which was never furnished to the petition. Take it that I am guilty as charged or punished.
Show cause notice states as to why the notice has been issued to you. And you have been awarded punishment under section 62.
What? Yes. So what I'm trying to see is that all this punishment, what they are trying to rely, should have been accompanied with the documents.
Not necessary.
Malak,
if you are not prejudiced.
Yes. Anyway, that is one of my ground. When there is a show cause, it cannot be without the record against me, whatever it is. Not by a mere show cause. Your lordship is clear that all this proceeding is in the English. In the show cause, new documents were furnished. Yes. Take the worst view of the matter that is my reply. Page 17. Clear for apology only. It's not a question of admitting a certain fact.
When does the question of apology arises?
My lord, as I have pointed out, the petitioner is illiterate in it, don't know English.
Then why this apology?
My lord,
why apology if he does not understand the contents of the show cause?
My lord, how it was written? It was written from the hometown by his brother when the petitioner was in Queensland. So take the worst view of the matter that it is an apology. Still then, what was the punishment? And we allowed to refer to my affidavit in reply. Because section 97, which is just like Article 20 of the Constitution, there cannot be a second punishment. Section 97 itself prohibits when somebody is punished under minor acts, minor punishment, no second punishment.
Why not?
That is the
What about the
prohibition.
instructions?
No, that is the prohibition in the section act itself. Constitution comes first, then act, then rules. Office instruction, what my learned friend is relying on, is 99, my lord. That is what the filing. Additional. My lord, you may say this. What do you furnish to your lordship is page 13, record office instructions of number 4 of 99. That is before your lordship. Then how he was punished? Page 18 of the writ petition. What we have relied is paragraph 5 of record office instructions 1 of 2004. In their producing to your lordship 99. They are saying that I am guilty of 2004.
Mr. MT,
Yes,
can you please do me a favor?
my lord.
Why don't you submit your submissions in writing? I am not able to get you.
My lord.
We'll leave it as spotted. Mr. Yangawati,
My lord,
kindly make your submissions and clearly incorporate all the laws, all the acts in
My
your
lord.
written submission. Jumping from here to the other, I think that is really confusing.
Yes, yes. But one fact is that the petitioner was discharged under act in use. It is already there. What we have referred is in paragraph 5 of record office instruction 1 of 2004 in their placing of 1999 before your petition.
So, in order to let me properly understand, clearly understand, I would request both of you to kindly submit
Yes, Your Lordship.
a very clear written argument incorporating all the acts. Because you are referring to so many provisions.
Yes. Act is there. Rules is there. Regulation is there.
And
Then
Mr.
apart
Yangawati,
that,
My lord.
they are
on the next date, kindly furnish this manual also.
My lord.
You are referring.
Yes, my lord.
So let us be very clear. I am still not, frankly, not able to understand your case, frankly. So I think your written argument will help this court. Kindly give me a clear written argument, chronologically, and then your case, so that I will be able to understand your case. When can you give me? When can you give me your written
Monday?
argument?
Monday.
Yes, Mr. Yangawati.
Okay.
When can you give me?
Make it on Tuesday, Lordship.
Tuesdays. 6.
My lord.
Third, Mr. M.T. Longchamp, the learned counsel for the petitioner. and Mr. Gauhati, Leonard CGC. Heard in part, listed again on 6/8/2024. Stop. The learned counsel for both the parties shall also submit the gist of their written argument. Okay. Kindly, submit the gist of the written argument, very precise, very clearly. So that, and then incorporating all the provisions of the law which you are referring. Yes, can you give this book? Yes, this is Potter. Okay.
For hearing, item number 51.
Lordship,
Yes.
it's almost time, Lordship. This matter will be taken up after Act 2.
What is the matter about?
Lordship, non-settlement of family pension.
Yes.
May I please, Your
Why have
Lordship?
you not settled? Yes.
Lordship, on last occasion, this honorable court has directed the principal AG to produce one letter, Lordship. So we have the
produce
letter. Yes,
one
Lordship.
letter?
Yes.
Yes,
Let
Lordship,
us see
that
that.
we did not annex in the opposition.
What, by which order?
26/2024, Lordship.
26/2024.
Lordship.
Original pension document is not traceable.
Yes, Lordship. So we have given this letter to the state government, Lordship.
Pension documents. Madam,
Petitioner is seeking for family pension, Your Lordship. The stand of the state government is that the petitioner's son was posthumously regularized, Your Lordship, and that regularization was done without due process of law. That's why we're saying that the regularization is illegal, Your Lordship. Because the approval of the government was not taken while while regularizing the petitioner's son, Your Lordship.
no, posthumous regularization comes. Why?
When
Why
the-
posthumous
The
regularization?
petitioner's son expired, Lord. He was on contract
This
service.
family pension in respect of who is the petitioner? The son?
The mother, Your Lordship.
The mother.
Of the,
Then who is this Im Namaran?
This is the deceased son,
this is son.
the son of the petitioner.
Son of the petitioner.
Lordship.
This petitioner's son was regularized, Your Lordship. He was serving on contract basis. And then after some years, Your Lordship, he was regularized posthumously, Your Lordship, by the Director of the Rural Development without taking the approval of the government, Your Lordship. That's our stand is that since the regularization was done without taking approval from the government, that regularization is illegal and he's not entitled for family pension. That's why.
How long did the son serve?
7 years, 9 months.
Ms. Inaholi, your stand is that the petitioner's son was regularized in service by an unauthorized authority.
Yes, Your Lordship.
Then what has happened to the order regularizing the service of the son of the petitioner? What has happened to that order?
Unfortunately, it has not been revoked or anything.
It has not been revoked, then
Yes, Your
pay.
Lordship.
If it has not been revoked, you cannot say that actually the petitioner's son was illegally appointed and then you cannot sit over it without revoking that order. You're seeking for family pension?
Yes.
Yes, madam, what is to be done now? You have allowed that person to continue.
Your Lordship, after the son expired, only his contract appointment was regularized, Your Lordship. He did not serve
That was in
after
the year
regularization, Your
2003.
Lordship.
It's
It was
more
in the
than
year
20 years,
2003.
He was regularized in the year 2003.
Yes, more than 20 years. They are coming with a plea that my regulation of my son is illegal, Lordship, after 20 years.
No, posthumous.
Yes,
Yes,
posthumous.
Lordship, after the date, Lordship. My son expired while serving as officer grade 2. After the death, the director regularized my service in the year 2003. Now we are in 2024, it's more than 21 years. My filing affidavit of position last year, Lordship, they are coming with a plea that no director has no authority to regularize my son's service. Whereas I list number of documents where director has regularized ad-hoc contract appointments. Even in the year 2004, 2006, 2007, I placed the necessary documents which was obtained through RTI. So their stand is contrary to their action, Lordship.
You pay. Since you have not revoked the order. What can this court do? This court cannot revoke that order.
Lordship.
What is the option left with this court? Okay, we'll resume at 2. Yes. Uh, Have you anywhere in your affidavit stated that the order appointing the petitioner by the director has been cancelled?
No, Your Lordship.
File
It
an
has not been
affidavit.
cancelled.
Where is that order regularizing?
Page 24, with petition. Twenty-five is the type copy. We come to page 29. Pension waivers were forwarded to AG. This is 2005. Page 33 also. Page 33 also.
Why it took you so long to file this petition?
Lordship,
22.
is Lordship,
When did
regularization 2003, Lordship,
huh?
and 2005, Director has forwarded the documents to the AG. Thereafter, the petitioner submitted a presentation, and page 33 also Director again forwarded, requested the AG to settle the pension. Page 33, Lordship. This on the basis of the representation submitted by the petitioner.
This letter is dated
Dated 16/6/2016.
32, page 32.
33, Lordship. Yes, 32. Yes, 31/5/2016. And page 33 is the forwarding letter of the Director to the Accountant General. Lordship, during this interpreting their Lordship, the petitioner was allowed to attend the pension adalat on several occasions, which was conducted by the AG.
It's not on record. But
That is not my bladed case, Lordship.
You file an affidavit stating as to whether this order dated the 30th October 2003 has been revoked or recalled. You file. You have not stated anything in your affidavit in opposition. We'll let her file an affidavit stating this. Only after that, thereafter we pass order.
Lordship.
Just specifically state as to whether you have revoked or recalled this order or not. That's all.
As of now, Lordship.
As on date. MS Inali, the learned government advocate, shall on the next date fixed file an affidavit stating as to whether the order dated 30th October 2003 issued by the Government of Nagaland, Directorate of Rural Developmental Blocks, Nagaland, Kohima, regularizing the service of, this is posthumous,
Yes, Your Lordship, posthumous.
posthumously regularizing the service of late Im Namaran, Officer Grade 2, has been recalled / revoked by the government as on date. List the case again on. When can you file? 1 week.
Your Lordship, 2 weeks, Your Lordship. Within 2 weeks, I'll file Your Lordship. A date may be fixed and I'll file it before the listing of the case, Your Lordship.
List the case again on. Okay. 12/8/2024. It is stopped. It is made clear that if no affidavit is filed as directed by this court, it shall be taken that no order has been issued by the government revoking / recalling the order dated 30/10/2003, posthumously regularizing the service of late Im Namaran, Officer Grade 2. Okay, we just want to make it very sure.
Yes, Your Lordship.
Okay, yes. Mr. Joshua, you have no role to play here.
Yes, Your Lordship, we have sought for the copies.
Correct.
My Lord.
For hearing, item number 52.
Yes, what is this matter about?
Is for family pension filed by the wife, my lord. My lord, what happened is this. The petitioner, he was page 37. Having been medically declared fit by medical officers, civil hospital doing sound, Mr. Such and such is appointed as AB.
Page
37, that is 36.
Of your
type
petition?
copy. Yes,
37.
yes. So he was appointed by this.
Let us go back to your appointment. Let us go back to your appointment. When were you appointed? Let us go back.
Yes. 36 is photo state which is not clear. So 37 is the date. Dated to the 13th September 82.
This is the appointment order or what?
My lord.
You were appointed as? You were appointed as?
Constable. With effect from 4/9/82 4 by the SB Twin Sangmalo. Then what happened is that my paragraph 3.
Take me to your documents first. Thereafter, what happens?
What happened is that the disease was detailed for parliamentary election duty while proceeding from Longling to Yongya village. The vehicle bearing registration number such and such G met with an accident and died while performing Punakhay government.
You are reading para
3
of your
page 7
of your petition.
my lord. Leaving behind the petitioner, wife, son Nayang Lu, and S. Peng Langpung, 2 sons. Then
Just wait, just wait. You were appointed 39/82 and you died on 27/12/84.
my lord.
Yes.
Then page 38 is the death certificate. The dead body was handed over to the present petitioner, Srimati Alamla. So about the petitioner being the wife of the deceased.
This 39 is the type copy.
Yes. Srimati Alamla Chang.
Yes.
Then what happened is the main issue are those because of the nomination, my lord. That is service book, service shed, page 40. kind treat rule 43.
Huh. 43.
43, yes. Yes. Then he have given his kind treat rule, father, late Pen Yong Chang, mother, No One Chang. So that is the kind treat rule which was left behind by the deceased. That is how everything become an issue.
Father's name is?
Late Pen Yang Chong.
Bayan, your actual name is, the name of the disease is Ben Ye Min Jong.
B. Yang Pu Chang, son of Ben.
B. Yang Pu Chang.
Yes.
And-
Son of Ben Yim Chung Chang. Ben Yim Chung Chang.
You are making me more confused.
In the appointment order, my lord,
Father's name is Ben Ye Mong Chang.
Ben Yim Chung.
Mother's name is?
No One.
No One Chang.
Yes.
So what do you want to explain by page 43?
43. Here nominated to state in case of death is No One, the mother.
Here nominated to the estate.
Yes.
Is No One the mother. Okay. So the mother was nominated by this is government employee.
Malo. So after the date, page 43 is the obituary.
Is the
obituary of the deceased.
Page 43 of your petition?
53, 53. Type copy is 54. Obituary, Superintendent of Police, Tuinsang in all ranks, record the premature death of UPC 531P Yang Pu Chang of Tuinsang P, who died in a vehicle accident while proceeding to Yongya on election duty on 27/12/84. I, on behalf of the members of the force, convey heartfelt condolence to Pere family in pray the Almighty for granting eternal best to the departed soul. So after the day, rupees 10,000 family benefit fund was released to the nominee, that is the mother, No One Chang.
Where?
Page 55.
What is this lump sum FBF?
Family benefit fund. That is as per the nomination. Then my lord, what happened is this. There was communication between the office. The mother nor the petitioner knew about the family pension procedure. So except the whatever entitlement the deceased had it was given to the mother. Then only in the year 1986,
Yes.
there is between some due to the IGB, now DGB, sanction of family pension in TCRG in respect of less and such.
Which page you are reading?
Page 65. I am to forward here with the pension papers as detailed in list of enclosure for sanction of family pension in TCRG in respect of late Yang Puchang. Receipt of this may be acknowledged. So it was in the year 1986, 23rd May 1986. Then, when the pension documents were put up, page 67. This is by the Deputy Secretary of Government of Nagaland, Home Department, to the DC Twinsang in SP Twinsang. Type copy is page 68. Fixation of pay in respect of late such and such. Constable, I am directed to invite the reference to the subject cited above in to say that the government have sanctioned ex gratia compensation to the families of personnel who died while on election duty on 27/12/1984. You know, the fact is that this was not dispersed to the family on the basis of the information furnished. But in the case of Nasu Yang Pao, police constable, pay was shown at rupees 245 per month. While looking at the pay structure, it is seems that rupees 245 was his initial pay in the pre-1983 scale. This may please be verified. If so, his pay may be fixed under ROB 1983 on 1/4/1983 under ROB rules of 84 on 1/12/1984. Thereafter, his basic pay ILC pay in 80 on 27/12/84. That is the date of date. May be furnished to this department for further necessary action. This is a direction by the Home Department to the SP in DC Twinsang.
Nusa Yang Pao is the deceased government employee.
My lord.
So what happened after this?
Then IGB wrote to the Accountant General, grant a family pension in DCRD. I'm directed to see that Sri Sain Sach died on 27/12/84. His family become eligible for the grant of family pension in TCRG Form 18 duly completed in containing the orders of the pension sanctioning authority is forwarded herewith for further necessary action.
You are reading which page?
Page 69. Type copy is 70. Your attention is invited to the list of enclosure which is forwarded herewith. The receipt of this letter may be acknowledged in this office informed that necessary instruction for the disbursement of family pension in TCRG have been issued to the Treasury officer concerned. All the documents are enclosed. This is from the IGB office, accounts officer. Then on page 71. Now it is DGB. Then December 1996. To the DGB Nagaland representation regarding family pension in ex gratia. I have the honor to forward here with two representations for family pension, one for family pension in another for ex gratia payment, submitted by Srimati B. Alamla Chang, wife of late B. Yangpu Chang, constable who died on 27/12.
Who is this Alamla again?
The petitioner, the wife. In a vehicle accident during election duty. One of the cab is there, which is not legible. Escorting ballot box to the polling station. In this connection, it is clarified that the family pension has been initiated by this office, which was already finalized by AG Nagaland by letter number dated 17/9/86, which is not with the petitioner. Since the deceased has served as constable less than 3 years, that is what it appears. No family pension was awarded by AG, but the sum of rupees 440 have been sanctioned as pension gratuity to the family of deceased in the pension chapter have been closed down September 86. Secondly, as per the government letter number 27/26, ex gratia payment to the deceased family have been sanctioned. However, it is stated by the deceased family members that they have not received such payment from any office till today, which may please be looked into. Thirdly, the mother of late Constable Srimati Lupin, which is Nuva, have obtained a succession certificate in her name after the death of the constable, since the wife has remarried. That is what is 96. It is not a
Who is the petitioner? Either whether it is the mother or the wife.
Wife. So the word crap in here, remarried. It is not because of remarriage, because of the nomination kind rule. The mother was given whatever is entitled. Because pension cannot be family pension have to be the spouse and the children. So here they have introduced remarry, which is not the possession, to another man just after the death of her husband. My lord, you've already taken note that the dead person was handed over to the present petitioner, that is the wife. And this remarriage is till date it is incorrect factually. So it is not a question of remarriage because the nomination was the mother in the late father. So whatever they are entitled are given. My lord, you can.
Who has been nominated, whether the wife or the mother?
Mother.
And who is the petitioner here?
The wife. What the rules is, family pension, that is rule 54.
The nominated person is the mother.
Yes.
And the petitioner is the wife.
Mother. So just say that I, the government employee, I can nominate anybody for receiving my estate. But the pension will be a question of rule. So rule is very clear that it is the spouse, the wife or the husband, in the children. That is rule 54, family pension. Clear to your lordship, clear about the rule.
Forget about the rules now. Let's come to the facts. Why pension has been denied to you?
My lord, this is what they have reintroduced, remarriage. As your lordship has noted, as I've shown in the service sheet, the nominee is the late father in the mother. In the children, in the wife is not included in the rule. But fact remains that when the husband died, the dead body was handed over to the Alam Lachang as the wife. So remarried to another man just after the death of her husband. Again, recently.
So is it a dispute between the mother and the wife?
No, no. There is no dispute about it.
If I may clarify, your lordship.
Yes, I'm very confused.
No, at that point of time, as per the rules, the nominee, if it is a mother or father, they can only receive gratuity, but no family pension. And unfortunately, we are not the authority to go into the investigation of whether Srimati Alamla Chang is the actual wife or the deceased had children or not. But assuming that he actually had wife and children, then even if he has passed away, since the family pension cannot be enjoyed by the parents but by the spouse and children, so it is the department, the HOD of the department, that is the PHQ, your lordship, has to write to the Office of the Accountant General for adding them as nominees so that they can enjoy the family pension. But that step was never done. So your lordship, even now at this stage, if the department so desires to give family pension, then my lord, the appropriate authorities, the sanctioning authorities, the department.
It is the department which has to write to the
Yes,
agent
your
to
lordship.
include the wife and
My
the
lord.
children.
Yes, your lordship. That
So
is
why
not yet done.
This
my lord.
Mr. Imti is taking me all over Nagaland.
My lord.
Does the submission made by Mr. Joshua satisfy you? Huh? Then it is you who has to approach the department and request the department to include you and the children.
Your Lordship, if we go by 54
Of
of the CCS pension rules,
Rule 54, correct. Just wait, just wait.
then your Lordship, the sub rule 12,
Rule, just wait, Mr. Joshua, Rule 54. Rule 54.
Rule 54, sub rule 12, my lord.
Rule 54, sub rule 12, will grant a family pension and gratuity to the eligible members of the family of an employee. Is
Your
it
Lordship,
that?
no. As soon as a government servant enters government
Oh,
service,
just wait, Mr.
My
I
lord.
think this pension books,
my lord,
written by different authors, has different provisions. You are reading from?
I am reading from the book, sixth edition, Dwivedi Law Agency,
This is different.
updated and based on 7-pay commission report.
Yes, this is different.
May I give my book? To your
Yes,
Lordship?
can I just have it?
12A, very quickly, I'll read for your Lordship.
Yes, yes.
As soon as a government servant enters government service, he shall give details of his family in Form 3 to the head office. If the government servant has no family, he shall furnish the details in Form 3 as he requires a family. The government servant shall communicate to the head office and subsequent change in the size of his family, which he did not do, your Lordship. Then, your Lordship, more appropriately, it's the subsection, sub rule 21, your Lordship.
Twenty.
21. Sub rule 21. Sub-rule 21, 2, your Lordship. The following categories of CPF beneficiaries so on receipt of ex gratia payment in terms of the department's OM number so and so, dated 16/12/1997, are entitled to DR 143% with effect from 1/7/2012. The widows and dependent children of the deceased CPF beneficiary who had retired from service prior to 1/1/1986 or who died while in service prior to 1/1/1986 and are in receipt of ex gratia payment of rupees 605 per month. To your Lordship, if the same comes from the department to include them, and from the HOD, the sanctioning authority, the same comes to the AG office, then my lord, the same can be given effect too. But at the moment, there's no such letter from the HOD of the department, your Lordship.
Okay, government, is the petitioner entitled to pension?
With regard to family pension, the deceased was in service for less than 3 years, your Lordship. That's why pension was denied to them. And whatever service benefits was to be given was already given to the mother, who was the nominee of the deceased, your Lordship. And your Lordship, if there are any more dues left, your Lordship, if it has to be given, it will be given to the mother, who is the nominee, and not to the petitioner, your Lordship.
The issue is whether the petitioner is entitled to pension. Give me some citations which will show that actually you're entitled to pension. This GL Bhatia. No.
It was the wife, two separated. And he was not even a nominee. But the fact remains that we need his family, the husband.
Okay,
and the
assuming,
wife.
assuming that the wife is entitled. How many years you have to be served? How many years you have to serve to be entitled to pension?
No, for the date. There is no Taliban like that.
For the death of a government,
Yes. No.
regular government employee?
No.
Just give me the problem.
Uh,
Yes, Mr. Joshua. Is there any time limit prescribed for a government employee to enjoy a benefit, pension benefits?
Your Lordship, as far as the date is concerned, there is no time limit. Even if the government employee has served only for 1 day.
Okay.
Yes, my lord.
So if you are entitled, Mr. Imti,
yes. So
you comply with the procedures?
my lord, that is what I am coming to that. Then the petitioner filed page 80. WPC 73 key of PT 70. So by order dated 1/6/2017. I mean, it's a short order. I may be allowed to read out. The petitioner husband, late Sergeant Sarge, was appointed a constable under the establishment of his Sang by order dated 39/82 with effect from 4/9/82. While petitioner was serving as such, he met with an accident while detailed for election duty on 27/12 of 1984, leaving behind the petitioner and her two sons. The petitioner requested for ex gratia and pensionary benefit from the respondent. However, there was no response. Therefore, a legal notice such was sent to the Director General of Police, Nakalan. Respondent number 7 for payment of extraordinary family pension in other benefits in respect of the petitioner late husband. However, the said legal notice did not yield any result, inasmuch as the respondent number 7 made no reply to the legal notice. As the respondents were not responding to the request of the petitioner, the person read petition as filed. After hearing the learned counsel for the petitioner in on consideration of the material available on the report, it is said that the petitioner has made no representation before the competent authority. In view of the matter, this petition is disposed of. The motion states by directing the petitioner to make the representation before the respondent number 7 within a period of 2 weeks from the thereafter. The respondent number 7 shall consider the representation and dispose of the same by a speaking order within a period of 2 months from the date of receipt of the representation. Then the petitioner made representation page 82 to the DGB representation for payment of ex gratia and extraordinary family pension in any other benefits in respect of my husband late number 7 such. Sir, with due respect, I have the honor to state the following for your consideration and necessary action that my husband, number 7 such, being medically examined and found fit by the medical officers, civil service hospital, Sang was appointed as constable under the establishment of SP, Sang with effect from 4/9/82 in the skill of such and such. Plus all other admissible allowances subject to the verification of his character and antecedents by office order number dated 39/82, passed by the SP Sang in husband late number 7 such, while serving as police constable was detailed for election duty in while proceeding to Yungyang. The vehicle number NLG 8436G met with an accident in died while performing bona fide government duty on 27/12 of 1984. for leaving behind wife Alam Lachang, Sri Nayang Monglu San, Sri Is Ping Lang Pung San. Medical certificate dated nil also was issued by the CMO to some Nagaland stating that late husband was under his treatment and expired on 27/12/84. That during the service of my husband, such and such, service book was prepared in maintained and verified by the SP. From time to time, in on his date obituary note, such and such, as follows, which I have read out. That by office later dated 23/5/1986, there is speaking song awarded the pension table to the IGB Nagaland for sanction of family pension in discharge in respect of my late husband. In by office letter dated 27/2/86, Deputy Secretary to the Government of Nagaland wrote to the DC in speaking song.
Mr. Imti,
Yes,
kindly apprise this court as to why pension has been refused to you.
my lord. Page 86.
I have gone through this.
To the additional chief secretary.
He has no need to read. I have gone through this.
My lord.
I am asking you why pension has been denied.
You are just saying that had remarried. That is the whole issue.
So now inquiry is required if whether you are married or not.
Never.
We cannot prima facie accept your submission.
No. I've included the village council chairman certificate, page 87. Is never
Pension
remarried.
has been denied to you because of the allegation that you are remarried.
Mano.
Inquiry has to be conducted. On the face value of your submission, we cannot just accept that you are not
Mano,
remarried.
that will be sufficient for me. Let there be an investigation. If they are making an allegation, they could have made an verification to that effect. Because the petitioner is very clear that he have never remarried.
Where is the official letter which says that pension cannot be given to you because you are remarried?
Malot,
Where is that?
page 86. Page 72. Page 72. Thirdly, that is the last paragraph. The mother of the late constable have obtained succession certificate in her name after the death of the constable, since the wife have remarried to another man just after the death of her husband. This is what the SP have written. Then page 86 is the repetition of that word.
So is it for this particular reason that pension has been denied to
My
you?
lord, this is the only plausible reason. You have not given me any direct communication till date. So, as your lordship has pointed out clearly, if you are talking about my status, you have all the authority in the means to conduct an inquiry. Earlier, it used to be done by the vigilance. Now it is local. for any false representation in the service matter.
You have not received the ex gratia also.
No.
Have you
no,
received the ex gratia?
No.
What has your mother-in-law received?
Family benefit fund.
Only this. Only this.
Your Lordship, they have received.
Rupees created up to rupees 2352 as GPF, my lord. Page 64. No one jump, murder of the
So,
constable.
madam, only one thing which remains. The petitioner is entitled to pension, provided inquiry constituted shows that she is not remarried. That's all. That is what can be gathered.
Your Lordship, there are some conflicting opinions on this.
Yes, please.
The CAT, Administrative Tribunal, there has been some decisions where even if the widow remarries, she's entitled to family pension. If we go to the Army Tribunal, there are some decisions which goes against the claimant for stopping the family pension on remarriage.
On remarriage.
Lordship.
So to be on the very safe side, I think we should institute an inquiry. An inquiry by the Deputy Commissioner, I think that will be more, I think, reliable, Mr. Joshua, by the Deputy Commissioner.
No, Lord.
Where does she reside? She resides in Tuengsang town.
Yes. The mother is also still alive. Totally blind, but still alive.
Yes, what
Lord,
what benefits have been received? Just wait.
My lord, if I maybe allowed, there was an inquiry by the STPU Tuinsang, which has been submitted in page 79. It was only after this the writ petition was filed. So this may not be, they may have opted not to act upon it. STPU.
Also, it says ex-wife of late. Succession certificate was issued in your favor.
my lord.
But this inquiry report does not say as to whether you were remarried or
Married
not.
to- yes.
That letter 70, page 72 as well as, which is that other letter? Okay.
Page 86.
Yes, ma'am. Benefits grant.
Service benefits such as FBF.
Where have you stated?
Paragraph 3 of my affidavit, paragraph 5, page 3.
Of your affidavit.
Yes, Your Lordship, the first paragraph.
Yes.
Therefore, the mother of the petitioner's late husband being the nominee, the petitioner's late husband's service benefits.
Where are you reading? Which page?
Page 3, paragraph 5. 7th line.
Yes.
Therefore, the mother of the petitioner's late husband being the nominee of the petitioner's service benefits such as FBF, leave encashment, GPF, and death gratuity in respect of the deceased constable was settled and paid to
Okay,
the nominee.
okay. Mr. Rimti. There is no dispute. There is no dispute regarding the claim for pension between you and your mother-in-law. There is no dispute.
As to my knowledge, yes.
There should be no dispute,
As
Your
per
Lordship.
the nomination-
There should be no dispute.
There can be no dispute because the mother is not entitled to family pension.
No.
It's
Except
just
the wife.
gratuity.
Except
Yes.
the wife.
Yes.
Yes, Your Lordship.
Only
Just
allegation,
see that-
only allegation is that you are remarried.
That is,
And
the-
therefore-
yes, even if my mother-in-law applies, she'll not be.
She'll not
entitled.
get.
Yes,
Only you and your children.
yes. The only question is about the remarriage. I'm saying, my village council is saying that she was in is never remarried. That is very clear.
Mr. Joshua, who will be the right authority to conduct an inquiry?
Lordship, a fair inquiry can be conducted by the investigation, by the administration because.
By the administration, because
Yes, Your Lordship. This
there
is
is
to
to
do
do
with
with
the police
the
department.
police department.
Yes.
Okay. Mr. Inkilongchar, learned counsel for the petitioner. MS AIME, learned government advocate for the state respondents, and Mr. Joshua Shakti, the learned standing counsel for the accountant general, respondent number 10.
Lordship.
The present petition has been filed by the wife of late constable number or late number 531,
My lord,
Constable B. Yangbo Chang.
my lord.
Who met with an accident and died on 27/12/1984 while performing bona fide government duty. Stop. That this is government employee had left behind his wife, that is the present petitioner, and two sons, correct?
Yes.
Subsequent to the date of the late government employee, the mother of the deceased government employee being the nominee, has availed the service benefits such as FDF, leave encashment, GPF, and debt gratuity. Stop. The present writ petition has been filed by the petitioner claiming the family pension of the late government employee, namely Constable B. Yangbo Chang. Stop. The petitioner had earlier approached this court by filing WPC 73K 2017. And this court by order dated 1/6/2017 disposed the writ petition, directing the petitioner to make representation before the respondent number 7. Who was the respondent number 7?
DGB.
That is the Director General of Police, Nagaland, Kohima. And the respondent number 7, therein, was directed to dispose the representation within a period of 2 months from the date of receipt of the representation. Within 2 months.
Yes.
Where is the representation?
Page 82 to 85.
Stop. In terms of the direction passed by this court, the petitioner has submitted representation. However, as of date, no positive action has been taken by the department on the representation submitted by the petitioner. Stop. It is the case of Mr. Inti Longchar, learned counsel submits that the reason as to why family pension has been denied to the petitioner is because of the stand taken by the department that the petitioner is remarried and therefore not entitled to family pension. And this is clearly brought out by the letter dated 10/12/1996, written by, correct?
Yes, SP.
The Superintendent of Police to Engsang, Nagaland, to the Director General of Police, Nagaland, Kohima, and the letter dated 26/2017, written by the Inspector General of Police, within bracket HQR, Nagaland, to
I'm
the
not wrong, 20, my lord.
27/2017, correct?
Yes, 20,
26/2017, correct?
20, 20.
20,
Yes. To
written by
the
the
IGP
IGP,
headquarter.
Police Headquarters, Nagaland, Kohima, to the Additional Chief Secretary and Commissioner, Nagaland, and to the Additional Chief Secretary and Home Commissioner, Nagaland, Kohima. In view of the submissions made by the learned counsel for the petitioner, and to bring the present controversy to an end, it is felt necessary that an inquiry may be undertaken by the Deputy Commissioner Tueng Sang or any of the officers authorized by him to find out as to whether Srimati Alamla Chang, wife of Constable number 531, wife of late Constable number 531, B. Yangpo Chang, who is the petitioner in the present writ petition and a resident of Tueng Sang Town, has been remarried, correct?
Yes.
has been remarried after the date
of her
of
husband
her late husband.
on 27/12/19.
Oh, sorry, after the date of her late husband.
My lord.
The Deputy Commissioner to Insang and/or the authorized officer shall submit the report to this court. What should be the time frame?
Lordship, 2 months.
2 months. We give you 1 month, 4 weeks. Okay. Shall submit a report to this court. On or before twenty 27/8/2024. Stop. List the case on 38/2024. Okay. Yes.
For hearing, item number 53.
50. What is the matter?
The matter pertains to payment of minimum scale of pay, regular scale of pay, Lordship.
You are serving us
LDA cum computer assistant, Lordship.
LDA cum computer assistant.
Yes, Lordship.
In which department?
Directorate of Health and Family Welfare, Lordship.
And what is your pay?
Lordship, I'm getting my pay as per this ROP 1993, Lordship.
Huh.
I have sought some information from the department as to the ROP paid to the regular LDAs as well as the temporary employees, Lordship. And as per the reply, it clearly stated that the regular employees are getting the latest ROP, that is 2017, whereas all the temporary employees in the department, they are paid as per ROP 1993, Lordship.
But what is your nature of service?
Lordship, my service is clerical works as
No.
all the-
Is it ad hoc or?
Yes, Lordship. Ad hoc, Lordship.
Ad hoc. Then
Ad hoc basis.
You are not entitled. You are entitled only to the minimum scale of pay.
Yes, Lordship, minimum scale of pay, Lordship.
Yes, Mr. Nangami. What is your stand?
Lordship, the prayer of the petitioner is actually before this honorable court is to grant him the latest revision of pay adopted by the state. Now, the latest revision of pay is ROP 2017. Herein, Your Lordship, the state government has brought out that ROP 2017 by notification. And the applicability also is there enclosed. Now, the applicability says that the ROP 2017 is not applicable to all the categories of work charge employees. The petitioner's hearing is an ad hoc employees, Your Lordship. And therefore, the latest revision of pay cannot be granted to the petitioner. As far as the minimum scale of the pay is concerned, Your Lordship, the petitioner are here before this court basing on the Jajit Singh case, Your Lordship. Your Lordship is well aware, in fact, Your Lordship knows better. Jajit Singh case comes along with certain criteria setting at para 42. Now, the petitioner has to first fulfill those criteria that are prescribed under para 42. Then only, Your Lordship.
What is the prescription under para 42?
Lordship, para 42, there were as many as 17 conditions that are prescribed. One of the 2-3 of the conditions, Your Lordship, if I might be allowed to submit, says that a person who comes to the court seeking pay parity has to prove that he is working or he is performing the same works and duties as per the post that he is comparing himself with. Here is a case, Your Lordship. I have, in fact, stated that in my affidavit in opposition also. Besides making an environment, he has not given any documents or anything that shows that he is performing the same duties, Your Lordship. Not only that, Your Lordship, in one of the criteria, it says that for placement in the regular scale of pay, Your Lordship, the claimant has to be a regular appointee. The claimant should have been selected on the basis of a regular process of recruitment. And employees appointed on temporary basis cannot claim to be placed in a regular pay scale.
What should be the minimum scale of pay? Which should be payable to the
Lordship, the minimum scale of pay, as per this judgment, is not exactly prescribed, Your Lordship.
No. But the minimum scale of pay
Yes.
is the minimum scale of pay
Is the minimum of the
yes. ROP 2017.
See, yes, it should be the minimum of the scale of pay that is applicable.
Without any increment, nothing.
Yes, but for that, Your Lordship, he has to fulfill the criteria. If he is seeking the minimum scale of pay.
Okay, Mr.
under
Mohan,
this.
let us see the paragraph where you have stated that you are performing the same nature of work.
Paragraph 6, Lordship. Para 6 of the petition.
What should be the minimum scale of pay of ROP 2017?
Like, Lordship, the grade for grade 3
It
employees.
should be, yes,
Lordship.
yes, under ROP 2017. It is the basic pay plus DA.
Lordship.
Then what are the benefits which comes?
Even the increments, Lordship.
No increments, no increments. Very
But
clear.
Lordship, the minimum that has
What is the
that is
minimum?
that is
That's
entitled to
why-
any grade 3 employees, Lordship, in the department, Lordship.
That is why grade 3 employees in the department. So what would be the minimum scale of pay of the ROP 2017? It should be basic plus, DA plus, or any other benefits?
Lordship. Basic Lordship.
Basic plus,
DA and other allowances, Lordship.
I don't know.
Lordship, even in other similarly situated cases, Lordship, I have also enclosed one judgment of this coordinate bench of this honorable court, Lordship. In the case of Nivitos Hemas case, Lordship, the petitioner in that case was serving as a sweeper, Lordship. Now, this honorable court has given a direction to pay that minimum scale of pay that has been granted to the regular sweepers in the department, Lordship. That was the observation made here, Lordship.
You are now getting a ROP
1993, Lordship.
1993.
Yes, Lordship.
And under ROP 93, you are getting the minimum scale of pay of ROP 1993.
Yes, Lordship. And after 1993, Lordship, 99, 2003, 2010, and 2017, Lordship. This honorable court has also, by a division bench, Lordship, if I may be allowed to just refer to one paragraph, Lordship. division bench of this honorable court, where your lordship was also a member of this bench, lordship. Paragraph 15, that states about the facts as well as the direction, lordship. Paragraph 15, page 15. This is discussed about the Japjit Singh's case, lordship, and paragraph 15 is the operative portion, lordship. May I read, lordship? This is a division bench judgment. Furthermore, we are in respectful agreement that, and there is no quarrel with the law laid down by the Honorable Apex Court that equation of post and determination of pay scale is the primary function of the executive and not the judiciary, and therefore the courts ordinarily will not embark upon the dust of job evaluation, which is generally left to the expert bodies. It is, however, well settled that the principle of equal pay for equal work is applied where there is complete and wholesale identity between two groups of employees discharging the same work, and even a daily wage employee who is performing duties similar to that of regular employees is at least entitled to receive the minimum pay scale as paid to a regular employee. In the instant case, the respondent who is serving as a sweeper on contingency basis on a fixed pay has satisfactorily discharged her responsibilities of explaining that she performs the same work, duties, and responsibilities as discharged by the regular sweepers by making clear averments to that effect, which has not been dislodged by the state appellant. We are therefore of the considered view that the respondent performs the same nature of works and duties as that discharged by regular sweepers and is accordingly entitled to equal pay as that received by the regular sweepers. 16, in view of the discussion made above and the law laid down by the Honorable Apex Court, and taking into consideration all attending facts and circumstances, we find no infirmity with the order dated so-and-so passed by the learned single judge in WPC so-and-so. The state appellants are accordingly directed to carry out the work order dated so-and-so passed by the learned single judge within a period of 60 days from the date of passing of this order. This is in read appeal number 25 of 2022, and judgment dated is 20th of January 2023, Lordship.
Here in this case,
Lordship,
the state itself has admitted that they perform the same duties
Lordship,
and functions.
Lordship.
Whether you have denied.
Yes.
In which paragraph, let us see.
Starting from para 6, Your Lordship. Para 6, para 8, my lord.
Read para 6.
Para 6, my lord. That I may be allowed to read, my lord.
Yes.
That as regard the statement made in paragraph 5, 6, 7, 9, and 12 of the writ petition, the contention of the petitioner that state respondent have time to time frames rules for revisions of pay, and that the regular LD employees in the department are being granted scale of pay under ROP 2017 is admitted for the fact that the Nagaland Service Revision of Pay Rules 2017 applies to all regular employees of the state government. As with regards to the contention of the petitioner that she deserves to be treated similarly while granting benefits to all the similarly situated employees, the answering deponent respectfully states that the service of the petitioner is not similar to that of the regular employees for the fact that the petitioner is an ad hoc employees who are not appointed against any sanctioned post, whereas the regular employees are appointed substantively against a vacant post. And since the benefit of the Nagaland Service Revision of Pay 2017 is extended only to the regular employees and not to any category of work charge employees, and therefore the petitioner being an ad hoc employees have no right to seek for payment of salary as per the ROP 2017. As regards to the statement of the petitioner that she is discharging a similar duties and responsibilities with that of a regular LDA, the answering deponent respectfully states that besides making such a statement, the petitioner have not annexed anything in the writ petition showing that she is actually discharging a similar duties as that of the regular LDA. And in absence of any such matters on the court, she could not establish the claim made by her, and therefore the statement of the petitioner is false and misleading this honorable court. so as to let this honorable court pass illegal order in her favor, and hence this writ petition should be dismissed at threshold. Para 8, my lord, if I may be allowed to read. That as regards the statement made in paragraph 10, 13, and 14 of the writ petition, insofar as the principle of equal pay for equal work as laid down in the state of Punjab and others versus Jagit Singh and others, the same is admitted. The answering deponent, however, respectfully states that the principle of equal pay for equal work as laid down in the state of Punjab and others, extending the same to temporary employees, it is seen that in this referred case, the benefit of the principle of equal pay for equal work was granted to temporary employees concerned for the fact that there was no room for any doubt that the duties and responsibilities discharged by the temporary employees in the referred case were the same as were being discharged by the regular employees. However, in the instant writ petition, the petitioner has not established that she is discharging the same duties and responsibilities as that of a regular employees, and hence the contention of the petitioner that she is covered by the same principle and is entitled to the benefits which the regular employees are being granted are false and misleading and is therefore denied. The answering deponent respectfully crave the leave of this honorable court to rely on the referred case at the time of hearing.
Mr. Moore,
Lordship,
see, the law is very clear on this.
Lordship,
Just by making a bare statement,
Lordship,
the court will not come to a conclusion that you are performing the same duties and responsibilities as a regular employee.
Lordship,
Can you please file an additional affidavit, bringing on record
Lordship,
as to how the work, duties, and responsibilities discharged by you is similar to that of a regular employee? I think that will suffice,
Lordship.
because that is the law. In fact, it is you who has to satisfy this court.
Yes, Lordship. I agree, Lordship.
It is you who has to
Yes.
satisfy this court that you are
Lordship.
performing the same duties, responsibilities as that of a regular employee.
Lordship. Lordship, I have filed a reply, and if necessary, Lordship, if it does not suffice, I'll file an
Whether
additional
the
affidavit.
reply, in
Lordship.
your reply, whether you have a
Paragraph 6, Lordship.
reply. 5 and 6.
Paragraph 6, Lordship. May I read it, Lordship?
Yes, please.
The answering deponent begs to state that the nature of duties and
You
responsibilities.
are reading
Paragraph 6, Lordship.
paragraph 6,
Paragraph 6 of my reply, Lordship.
that with regard to the statements.
Made it paragraph 6,
Yes,
8, and
yes.
11 of the
Please,
state's.
please, please.
The answering deponent begs to state that the nature of duties and responsibilities performed and rendered by the answering deponent is apparent from the appointment order dated so and so. It is further submitted that the nature of duties and responsibilities performed and rendered by ad hoc employees and regular employees are similar in nature, as it is only when with the consent of the nature of employment that is different. Otherwise, the duties and responsibilities of the LD poses the same, be it ad hoc or regular LD employee. And as such, it requires no annexure to prove that the nature of work performed and rendered by the answering deponent. In fact, Lordship, just my humble understanding after reading the government's affidavit, Lordship, the only contention that the state has raised is the nature of appointment, Lordship.
Which department you are?
Health and Family Welfare,
Health and
Lordship.
Family Welfare.
Yes, Lordship, Medical Department, where Lordship may kindly appreciate the fact that the regular LDAs as well as the temporary LDAs, they're discharging the work of a clerical job, Lordship. All of them, Lordship. And the state does not deny that, Lordship. Paragraph 44.3 of Jagit Singh's case is also very clear, Lordship. The nature of appointment is not consequential, it is inconsequential, Lordship.
Nature of appointment is inconsequential.
Lordship.
But I think you will have to bring more particular facts.
Lordship,
by filing additional.
Lordship.
Because actually, in Jagit Singh's case, it is very clear that it is the petitioner who has to prove.
Lordship.
And just by making a bare statement that you are performing the same work
Lordship.
as that of a regular LDA, I think that by itself will not actually satisfy the requirements laid down by the Honorable Supreme Court.
In that case, I'll file an
You
affidavit,
give some
additional
particulars
affidavit.
at least.
Lordship.
You give some particulars.
Lordship.
That Mr. Mohammed.
Jamir, Lordship.
Sorry. learned counsel for the petitioner, and Mr. N. Angami, the learned senior government attorney for the state respondents. In the course of hearing, this court desires that this court desires the petitioner to furnish more particulars as to how the nature of the works and responsibilities discharged by the petitioner is similar to the work and responsibilities discharged by the regular LDS
Lord,
in the Department of
Health and Family Welfare.
Health and Family Welfare.
Lord,
The particulars that the petitioner is discharging the same or similar work to that discharged by the regular LDAs in the Health and Family Welfare Department shall be placed in the form of an affidavit. Listed again on when can you file affidavit?
to be on the safer side, 2 weeks, Lordship.
Listed again on 13/8,
Lordship,
2024.
obliged, Lordship.
Deeply obliged.
For hearing from the supplementary cost list, item number 61.
Yes, what is the matter about?
My lord, the petitioner was appointed as night leader.
As
Night leader in the Directorate Science and Technology. With effect from 1st April 2011. What happened? Sometime in
have you not gone through your file?
22, there was a vacancy. Which petitioner is night, we don't know that. There was a retirement in the post of sweeper. Who the petitioner applied. So, any selection or recommendation, just forward the application. But in the application, my name is given as serial number 1.
Okay.
But what happened is that a new applicant, a fresh applicant was given approval. So the petitioner approached this court. However, appointment order was issued by the director. So the writ petition was disposed of, withdrawn and withdrawn.
Appointment issued by the director in favor of
The private respondent number 5.
so writ petition was withdrawn.
Yes, then this is the subsequent petition before your lordship. I'm challenging that appointment notice.
What is your right?
My lord, I'm the senior most among the contestant for Great Star.
In which department?
That is Science and Technology. There is only one directorate, there is no other office. So what I'm stating is this. The petitioner being the senior most, which was duly forwarded by the directorate to the government for approval. Page 31. This is to the Commissioner and Secretary. Submission of list of applicants for filling up a Group D post in the department. With reference to the above said, the subject, I am to submit here with the compiled list of applicant for filling up Group D in KS vacant post in the department.
You're reading page?
Page 31, Annex 9. Includer includes as stated, that is, list of applicants for filling up Group D MTS vacant post. Serial 1 is the petitioner. Night to be there. Date of appointment 16/3/2011.
Now, what is the private respondent?
Serial 7.
Serial 7 is the private respondent.
Yes. Serial 7 is Srimati Sajin Sach. Designation none. Date of appointment none. Remark.
This are all this grade 4. Grade 4.
Yes.
What is the practice in the department of regularizing?
Malord, earlier one vacancy arose. Then the senior most was regularized. That one, Malord, page 24 may be seen.
When was the private respondent appointed? Nothing is of fresh.
Yes, free. Earlier, as you know, she was with the query, page 24 may be seen. What happened earlier?
No, you were appointed in the directorate.
Yes. Actually, the petitioner, he was tasked to be the night leader when the directorate was under construction. To reconstruct the temporary shed. Use the material have to be taken care of. That is how he was appointed.
Miss Mary, what is the practice followed in the department for regularizing?
For regularization, here the department has applied this 2004 scheme, Your Lordship.
2000?
50/50, yes, Your Lordship. And the first resultant vacancy was given to the senior most. Now the present post is for direct recruit, Your Lordship. So accordingly, the department has come up with a mechanism and.
Have you mentioned that in your affidavit?
Lordship.
Let us see.
Lordship. Para 11, Your Lordship.
Yes, wait, Para 11.
Yes, Your Lordship. That with regard to the statements made in paragraphs 10 of the repetition, the answered deponent respectfully states that in accordance to PNR OM dated 22nd of September 2004, clause 3 and 4, the department is maintaining 50/50 basis policy. Hence, in March 2017, the first resultant vacancy was given to contingency employee Srimati Novozolu Kamo. Accordingly, the second resultant vacancy has to be filled by fresh candidate on 50/50 basis, Your Lordship.
What is the criteria adopted for selecting the fresh candidate?
That, Your Lordship, is there is an OM, Your Lordship. It's at page 9 of my affidavit in opposition. The office memorandum. The relevant para is paragraph 4, Your Lordship.
Whether the respondent number 4 is,
Five.
five.
Respondent number 5.
No, there were actually 3 fresh candidates.
Lordship. So all the application has been forwarded to the government and
What was the criteria for accepting the appointment of the
that it
respondent
has
number
to be done through open advertisement, your lordship.
open advertisement?
Yes.
Was open advertisement
Here
done?
we have to be fair, your lordship. We did not advertise, your lordship. Page 10 of my affidavit, your lordship. OM. Clause 4,
Yes.
your lordship.
Will it not be proper if this code says that proper advertisement should have been there to appoint the fresh candidates?
Your lordship, that I leave it to your lordship.
Okay, we accept 2004, we accept that.
Yes, your
As
lordship.
per the scheme, it has to be on a rotation basis.
Yes, your lordship.
We accept that.
Yes, my lord.
But
Dear-
even among the fresh candidates, I think there has to be a fair selection.
Lordship, that's true, your lordship.
Your affidavit in opposition, page 11, 2004. Roman 3. 50% of all regular vacancy of similar nature arising in a year, my lord. It is in a year. So earlier it was 2017. So going by 2004, arising in a year. I hope I might learn it in submission.
No, what you mean to say is that even this vacancy has to be given to you.
My lord, because the OEM is in a year. 50% in a year. It's not a question of looking up the whole lot from the day one up to
If your contention is to be accepted, the fresh appointment can never be appointed.
Yes.
My lord, it is not my contention. What I'm saying is the OEM, my learned friend, is bringing before you.
It is always alternative. Always alternative. The senior most, then the fresh, senior fresh, senior fresh. It is implied.
No, what I'm reading is the.
You're as per the OM.
Yes.
You're reading as per the OM.
Yes. Roman 3.
But that does not give you any right.
My lord,
The OM does not give you any right.
My understanding may be wrong, but one fact remains that my learned friend is saying that when 2004. So in 2004.
Yes, Mr. Moa, what is your right to be appointed?
Roman 3.
What is your right to be appointed? There are so many fresh candidates, but what has favored you so much?
Lordship,
You seems to be a blue-eyed boy for the government.
Lordship, I have very limited contention on this case, Lordship, limited argument, Lordship. I have pointed on only one question of maintainability, Lordship. The fact remains that the petitioner was appointed on contingency and he is still on contingency basis. And even the appointment, Lordship, I have to fear enough with my submission that my appointment was also without any selection process, Lordship. However, Lordship, in such kind of a scenario, Lordship, that there's well settled principle of law that ad hoc can be replaced only by a regular selection process, Lordship. And ad hoc cannot be replaced by another ad hoc. The prayer in this writ petition is that he has to be replaced in that vacancy, existing vacancy, and he is on ad hoc basis, Lordship,
Okay.
or
the-
temporary basis,
the-
Lordship.
This court,
So-
this
so he
court may
cannot-
find fault with the prayer of the petitioner. But why are you the most favorite among the fresh candidates?
Lordship, that's why my limited prayer is that if this honorable court comes to a conclusion that there has to be a regular selection process, I mean, we can be allowed to continue this till such selection process is held, Lordship. Because, and also my argument, Lordship, my argument before this honorable court is that he has no locus to challenge my appointment, only on the ground that he is also an ad hoc employee and he cannot replace another ad hoc. Lordship, just to
No, that.
support my contention, Lordship, if I may.
You
allowed
were
to-
you were appointed as a regular.
No, Lordship.
You
on
were,
ad hoc.
you are
An ad
appointed,
hoc, Lordship.
you are still on ad hoc.
Yes, Lordship. An ad hoc.
Ad hoc.
So my ad hoc appointment cannot be challenged by another ad hoc, Lordship. To substantiate my.
No, I know the law,
Lordship.
that I know. But the law is clear that even for ad hoc appointment, it should be open to all. Even for ad hoc appointment,
Yes, Lordship, I agree that.
you
Lordship.
have no exclusive right.
I agree that. Therefore, my respectful submission before this honorable court is that till such time the regular selection process is conducted, if I may be allowed to continue, and also to
Yes.
participate in such process.
Mr. MT,
My lord, if he is continuing, it will be in opposition of this honorable court.
no.
No,
If we had to go by the 2004 notification, the privilege available for appointment is only to the fresh candidates. Not to the contingency.
Because-
Your turn will come next.
my lord,
Your turn will come next. Definitely, your turn will come next.
what I am,
Not for this case.
what I am saying is this. Her appointment is, it is a regular vacancy. In this honorable court, on 11/11 of 2022, already state.
Let us see the appointment order of the respondent number 5.
There is no author system here.
Yeah, this is not a.
No,
This is regular.
and already.
The only
state-
thing is that confirmation of service on the recommendation of the.
That's
medical-
a proportion, which is normal for any regular appointment.
But Mr. MT, where is your right?
My lord, my right is, as my learned friend has pointed out, 50% in a year has to be considered for the irregulars.
Okay. So if your contention is taken, then for any vacancy which is not published in a year, you are actually making a submission that it is the contingency employee who has the right.
My lord. So if this, see, if 50% in a year, that is what the government is seeing in their submitting on that time. So if there are two, it will be 50-50. First, the reserve comes first.
Okay. We will also give you the liberty to actually appear in the interview, in the advertisement. Okay. You retain both the benefits. As a contingency, you apply for the advertisement. If you are not successful, you still retain your lien over that contingency post.
Apart from that, my lord, my prayer is for equal pay from the day of my appointment, all along,
From the date of your appointment,
my lord.
maybe it can be prospective.
Either way. Or it is prior to 3 years, prior to the filing of the petition.
Let us see your, let us see your contention about equal pay. Let us see, where have you stated?
Para 17.
Para,
Para 17.
para 7.
17. 17.
Just by citing Jagdish Singh's case,
Yes.
you may not be
18.
entitled.
Yes, 18 and 19.
You have nowhere stated that you perform the same duties and functions as that of a regular employee in the grade 4 post. Heard Mr. Imti Longchar, learned counsel for the petitioner. MS Mary, the learned senior government advocate for the state respondents. And Mr. Moajamir, learned counsel for the respondent number 5. Okay. We pass the order. Pass the order. Yes, dispose. Yes, next.
That's okay. Yes, sir.